Yes.
My lord, I have a prayer for moving an unlisted, my lord, I in a pending RFA.
How is it possible to moving an unlisted? What's the wrong?
Tomorrow, my lord, what has happened, my lord? This was a suit for, my lord, my eviction. I am a tenant. I have a corporate office in the buildings, my lord. Then, my lord, there was a conditional stay from this court. We came against the decree, my lord. Conditional stay, you pay the current rentals and then you. Now, our ground there for not paying is that the landlord was not providing us with the GST invoices. Now, GST invoices have been made available on 1st of March, 2 days back, man. Now, that order has been passed, my lord. That is all right, my lord. Only along with that, my lord, I'm just reading on they have reissued the writ of possession and attachment, my lord. And a police call has already been received from the police. They try. We
When
need
is
some time, my lord, against the we are
When is
ready
it?
to pay,
When is it?
my lord.
The writ of attachment.
Next date is, my lord, next date is 5/4. That is all right, my lord, but the police is, my lord, has already given us a call, my lord. We do not. We need some time to pay. We have said, we have not contested that, but we are paying.
Wednesday?
Wednesday. Can it be taken up tomorrow?
What is the urgency? I don't see
Only
any
for that
urgency.
police part, my lord, nothing else.
Okay. Tomorrow. I don't pick matters on Tuesday. When it should be on when it no heavens will fall.
What's up?
I am interim order file.
Huh?
Interim order, interim order. I am I was filed on 8th, 2nd of 8th of February.
Not Wednesday, Friday.
May please. May please. My lord, there are appeal, my lord, for admission. Can it be on Wednesday, my lord? Of like.
The document, one FAO and one RSA. They are
When? Why?
there is some market.
FAO.
One is FAO, one is RSA.
Okay. We'll have it on Wednesday, Friday.
Friday, holiday is there.
Friday is a holiday. Oh, in another matter, then we'll have it on Wednesday. So Wednesday good.
Please, your lord. My lord, in item 23, I filed an additional affidavit. I may be permitted to come. Pray for listing of this, my lord, CRP on Wednesday, my lord. It has been settled, my lord, regarding a decree where, my lord, interest has been accruing every day. It is now, my lord, settled it with the authority or other side. Can it be on, my lord, Wednesday? Please,
Your Lord. I beg to petition item number 55. It has been wrongly listed in the hearing column. In the orders column.
It has to be listed where?
In the orders column.
Okay, we'll take it as orders. Don't worry. The order is the payment.
If please, your lordship, I wish to mention item number 14. It may be listed after a week, lordship.
Why?
Because it is an FAO, but a IA is yet to be filed in this under.
Don't file the FAO. I then we'll dismiss it. Don't worry. But don't make us. You must have forgotten.
Yes.
I don't give adjournments just for the sake
And
of.
the engaged counsel is also not present today.
Very well, you do it. Next.
May it be the lordship.
I your lordship gave it in 8. 8 is holiday. So it's on next.
Wednesday.
May it please the lordship. I beg to mention 2 CRP IO lordship for listing on Wednesday motion letter. Apply.
Yep, Your Lord. But I beg to mention that this matter may be listed for hearing. It's an MSc appeal. Listed
Can't hear
for
you.
Hearing. Your Lordship, this matter may be listed for hearing on 7.
Yes. When do you want it?
7. 7.
7th. 7th is Thursday.
Yes, Your Lord.
Why?
For hearing.
Hearing, no. Hearing is not listed in this manner. You take it up with a raised fee. Hearing can't be listed with a main.
I beg to mention item number 5. So I'm making this mention on behalf of Mr. A.K. Gupta, Your Lord. the consent of the other side has already been obtained, Your Honor. So if Gupta has some ethical urgency,
We'll see when the matter is reached.
May it please the Lordship. In item number 34, Lordship, come for order, one application has been filed. But copy is served to some advocate clerk. I am not getting the copy, Your Honor. Lordship.
We'll see when the matter is.
Lordship, to mention item for listing, Your Lordship. It's a RFA 2018 matter. It is last listed on December 2020, Your Lordship.
Why do you want it listed?
It has not been heard for a long time, Your Lordship.
You want it in the hearing column?
No, Your Lordship. It was there in the hearing column for more than 2 years, but it was not listed, Your Lordship, in some.
It's in the hearing.
So now it is not in the hearing column.
Mr. Counsel, yeah, Mr. Roy comes in. Yes, Mr. Roy, what is this?
This is money to law. It was fixed for hearing. Thereafter,
So, fixed for hearing, you file an IA for early hearing. You can't mention in the matter like this.
it was already fixed for hearing.
Understood. If it is fixed for hearing, how can I?
Okay, my lord, I'll take it.
Is there any column out there in the mention memo for hearing?
Lordship, I am making a permission to move an urgent appeal, Lordship,
Today?
against demolition. Not tomorrow.
Tomorrow? No. Wednesday.
For motion item number 1.
Yes, what is this CIP business?
May I please, your Lordship, in this CRP, Your Lordship, I have a filed a suit. And that suit was rejected on order 7 to 11 by invoking section 11 of the CPC. That is,
You filed a suit.
yes, Your Lord.
Suit for what?
Suit for
Where's the plaint?
My plaint is, Your Lordship, page 77.
Suit for right title interest.
Your Lordship.
Recovery
Free
of
of
the,
position and permanent.
okay, why was it rejected under order 7
It
rule?
is rejected because earlier there is a earlier round of litigation in between the parties wherein the defendant has filed a suit for declaration and permanent.
On the question of res judicata.
So there is the res judicata.
So on the ground of res judicata, it was dismissed.
Yes, Your Lord.
Then what happened?
So I came before your.
It is against that.
Yes, sir.
Yes. How is it possible to reject a suit under order 7 rule 11 on the point of res judicata? Because you have to see only on the basis of the plaint.
My lord.
That can be only taken
lord,
as a preliminary
My
issue.
lord, the issue raised in the suit filed by the other side is same is in the other, my lord.
Absolutely, there's no quarrel with that proposition. But the fact that can you see it only just on the basis of the plaint? Because the Supreme Court in one judgment,
Your Lordship.
where is the judgment?
Your
Has
Lordship.
categorically stated that you cannot take the issue of res judicata in a as a order 7 rule 11
Your
proceeding.
Lordship. Recent judgment, Your Lordship.
It is by Justice D.Y. Chandrasud.
Two judgment, one judgment, Your Lordship, par number 7 of 2003, Your Lordship, par number 11 and 12. Lautian took part.
This judgment is okay. I think this judgment is suffice. Yes, what is there? We set aside this
Well,
order, let the trial proceed.
My lord, they claim for disposition, my, in the suit. My lord, they are never in the position, my.
Very well, that is another aspect of the matter. Whether they are in possession or not, the question is, could the proceeding, could by way of proceedings under order 7 rule 11, could you have dismissed, rejected the plaint? on the plea of res judicata. That's all. Can't be done. The law is very
My
clear.
lord, the other second appeal before lordship, my lord, in my suit, was dismissed by the trial court, dismissed by the first appeal, then my lord, second appeal before this. That second appeal is also pending before this. My lord.
Understood.
My lord.
That second appeal will be taken as it is. But can the plaint be rejected on the issue of res judicata? Let's see your plaint.
My judgment.
Where was the earlier suit?
So, look, it is the only judgment, it is annexed.
Huh?
Judgment annexed.
We have only enclosed the judgment.
Even in the suit, you also, your lord.
Where is the impugned order 29/3/2023?
Your lord.
Have you filed your written statement?
Yes,
Yes,
my
your
lord.
lord.
Yes, we have filed.
Has the issues been framed?
My lord, no issue.
So we do one thing. We set aside this, let the issues be framed without prejudice to all these things. Let the court decide as a preliminary point, res judicata.
Yes, my lord.
That can be done. That is the only way out. Because without framing the issue, under Order 7, Rule 11, you cannot reject the plaint. The law is very settled. Only way out is let them
The issue
frame
will be
the, as
framed.
written statement has been filed, preliminary issues can be framed, and if one of the issues can also be decided out there.
Your lordship. Here in this case, my mission is that as because the appeal is, second appeal is pending, the only thing applicable here is the section 10.
As
Section 10, your rest of the things.
no, why not? Why can't not only Section 10 can be very well applied,
Your lord.
but apart from that, why can't the suit be decided on the preliminary issue of res judicata?
Your lordship, herein, they filed the suit before the trial court. And the finding of the learned trial court is not that right at interest was decided in my favor. It is negatively decided in his favor, your lordship, that he didn't have right at interest and possession, your lord. The trial court has decided that, appellate court has decided that ultimately in appeal, second appeal is pending before this court. So I have never filed any suit. I have never filed any counterclaim. So where do I go?
I am not,
doing the pendency of second appeal.
Mr. Jha, these are things which is to be argued before the trial,
Your lord.
not before me.
Your lord.
Let us limit our case to what it is before
Your
this. Look, And why are you filing a 227?
115, Lord.
Huh?
115.
Why 115?
Because it is a termination
When a
of my
plaint is rejected, isn't it a case of appeal?
Appeal.
How do you file this? An appeal lies. What is the valuation of the suit? $50 lakhs.
Your Lord. Appeal lies before the
Appeal lies before this court. We convert it.
Well.
We convert it and hold it as an appeal. But have you paid the court fee?
process. I have not paid.
You have to pay the court fee. How do I?
I'll pay the court.
The 11,000 has to be paid.
Your
Then
Lord.
only we can take it up.
I'll
Mr. N. Jha, the learned counsel appearing on behalf of heard Mr. N. Jha, the learned counsel appearing on behalf of the petitioner, and Mr. A.R. Sikdar appearing on behalf of the respondent. The instant revision application is directed against the order dated 29/3/2023 passed by the learned court of the civil judge Borpeta in title suit number 4/2021, whereby the plaint of the petitioner was rejected under the provisions of Order 7, Rule 11. It is well settled that when a plaint is rejected, it amounts to a decree, and consequently, an appeal is required to be filed. Mr. N. Jha, the learned counsel appearing on behalf of the petitioner, submits that taking into account that the appeal lies also before this court, he may be permitted to this court should or to convert the appeal or convert the instant proceedings into an appeal. This court have also taken note of that if an appeal is filed, the court fee has to be paid as per the value of the suit. However, the same having not been paid, the learned counsel for the petitioner submits that he may be permitted to pay the additional court fee within 2 days. List the matter again on 11th of March 2024. In the meantime, the petitioner is directed to pay the additional court fee, and thereupon the matter be listed before the court. For admission.
Keep lovely. Team number 2.
Yes, what is this? Transfer from where to where?
From Coringhurst to Seattle, Lordship.
Who are you?
Lordship, I am the petitioner is the wife, Lordship. She is staying at Seattle,
Coringhurst
Lordship.
to Silchar. Nearby.
Lordship,
It's only 30 kilometers or 40 kilometers.
70 kilometers.
Oh, very well.
And apart from that, Lordship, there are 2 children are there, Lordship. There is not to look, Lordship. And husband is staying at Dubai, Lordship. And he
Huh?
husband is staying at Dubai, Lordship.
So how do you affect the service?
Lordship, everything, because he also filed the transfer petition. I have annexed the page number 68.
Where does he want it?
He also praying for transfer of my suit to Coringhurst, Lordship. As well as in the prayer portion, he
So where is the transfer petition?
page transfer page 68 is the Lordship. Notice was issued in that case, Lordship. I filed also my wakalat
Page
transfer petition 4 of 2000.
Page
68, Lordship.
68.
Nectar I.
This is the matter on Wednesday. I did to the along with transfer
Lordship, may I
petition
say,
number
Lordship?
4/2024. Let that matter be there. We transfer it then on Wednesday.
Team 3.
Lordship, may I say, Lordship, I may be next week any day subject to permit.
Huh?
I will be out of station for
On Wednesday.
Lordship.
Okay. Then I ask your junior to be present.
Lordship. This transfer petition
filed by the wife, husband filed a patent took marriage in Sonitpur, and wife marriage took place at Hojai, and wife resides at Hojai in her paternal home. Already, my lord, the two cases are pending in Hojai, my lord, that 125 proceeding and 40.
When is the next date?
My lord, tomorrow, my lord.
Then why have you filed it today?
No, my lord,
Why have you filed it on 28th of February? You knew it. When was the date given?
My lord, it was
The notice was issued on 25th of January.
my lord, this
Then?
notice only, my lord, 19/2, my lord. 19/2 it is received.
Then?
19th of February.
Then why should we state?
Received that, my lord, that is put it in an extra.
How are you going to serve it? Serve the application?
My lord, the justice service.
Husband stays at Tejpur
Right.
and wife stays at Hosai.
Hojai. There is another two proceeding, my lord, running in my lord, Hojai, and husband is appearing in Hojai.
You know, heard Mr. So-and-so issue notice making it returnable on 11th of March 2024. You are going to serve it before that, 11th of March. 1 week time. 11th of March, no, 11th of the, on 15th of March 2024. Full stop. The petitioner is directed to take steps upon the respondent number, the sole respondent by way of registered as well as usual. Further to that, the petitioner is also directed to take steps by way of trustee routed through the registry of the court and file an affidavit of service on or before the next date. Full stop. The petitioner herein is the wife who, on account of various difficulties which she would face if these are divorce proceedings. In the circumstance, the divorce proceedings are decided, are taken up for adjudication before the district judge Sonitpur at Tejpur have filed the instant transfer application. Taking into account the above, this court is of the opinion that before passing any appropriate order, the respondent, the sole respondent, is required to be heard. Accordingly, this court would hear the respondent on the next date. Till the next date, the further proceedings in TSM number 57/2023 pending before the court of the learned district judge Sonitpur at Tejpur shall remain stayed.
Obliged.
Correct.
Yes,
Lordship, as per last order dated 7/2/24, Lordship, I was asked to take instruction, Lordship. The Planet Government Council also take instruction, Lordship, regarding that application.
this is not a parted matter. How do you show? Where is it written this is matter is parted?
Malad TJ month last day, Malad after the court hour, Malad. He informed me that as per the honorable court's order, the blocking part.
I remember this case.
Yes, and he
But,
said that
But
by
Mr. Chetri, this court is not taking up this roster, and consequently the difficulty is you don't get proper assistance from the government.
no, since the government now they are saying they are retain later.
This matter before the appropriate bench now. Taking into account that the matter has not, that this court is not presently taking up this roster. of Civil Bench 5 and the instant proceedings pertains to the said bench, the registry is directed to list the matter on Wednesday before the appropriate bench.
Public.
Item 5.
What is this?
Not
Hmm.
by that the substitution be given by
What are you challenging?
order dated the 10/2021 next 30 for
Mr. Counsel, what are you challenging?
order for not granted to appear. Accommodation may be granted to the
Why? Yes, Mr. Kaiwala, what is he challenging?
My lord, the counter claim has been directed to be treated separately, my lord.
Huh?
They filed a counter claim and which has been, my lord, directed to be treated separately, my lord. I think,
Why?
my lord, that the possibility, my lord, that they
Where is the order?
page 43, my lord.
53. Then
Yeah, big some my lord. It says the got expenses count.
this is an order of review.
That is last. At page 53, my lord.
Page
Page
53.
53, yes.
No, page 53 is the order of review.
Review, my
They are challenging the review order. What is the order you are challenging?
What if both order dated 10/2021 as well as 2/3/2024.
You are a plaintiff.
I'm the plaintiff, my lord.
Now, what has happened in the case?
He filed written statement as well as counterclaim. Counterclaim, he has said, my lord, he has made some construction incurring 10 lakh. That is why he is not.
Then,
That is, my lord, that has been excluded.
Was rejected by court. Then
My lord, just, my lord, to delay the disposal of the
no,
book, my
first
lord.
of all, you are not clear. Both of you are not clear on your submissions. It's a
Fine.
suit filed by him.
Yes.
For what?
Yeah.
Right title interest or the, it's a landlord tenant
Eviction of tenant.
eviction. Now, why he has filed a counterclaim?
Counterclaim, my lord. He
Saying
said
that-
that he is not a defaulter. The rent was not accepted by us, my lord. Then he also filed a counterclaim saying that he has made some construction incurring 10 lakh. That is why he is not a defaulter.
Now, 10 lakhs, what is he asking for? Let's see the
That's page
counterclaim.
23, my lord. Page 23, your lordship.
Additional ground. Now, what is the prayer?
A prayer, my lord, there at page 24.
Confirmation of
Declaration that defendant was not a defaulter. A suit which occupies the suit premises and adjustment of expenses. This is a plea, my lord, sir. Just
So why both the suits can't go proceed together? Claim and counterclaim can't proceed together. The relief which he is seeking for is not outside the purview of the judge. Then, isn't the order wrong? Within that amount to multiplicity? He's asking, what is his relief? Declaration the
Madam-
defendant is not a defaulter. That is
my lord,
nothing.
no, but only thing, my lord, he wanted that he made some construction.
Understood. He had made the confirmation or ascertainment of the building investment made by him. That's a decree.
Yes.
Cost of the litigation. His relief is not beyond the 2 lakhs. So under such circumstances, why both the proceedings couldn't have been taken together unnecessarily? You should be more prepared. Huh?
On behalf of the medical urgency.
Your suit is for landlord tenant.
Yes.
And he says that he's filed a written statement. So against filed a written statement to that effect and saying that he's not a defaulter. So why both the matters can't be taken up? Okay, Leho, we allow this.
My
to
lord,
be-
maybe only, my lord, direction may be given to estimate.
Absolutely, that unnecessarily this matter is stayed.
That's on 19 meter.
Do you have any problem in allowing the petition? No. Heard Mr. So-and-so, the learned counsel appearing on behalf of the petitioner. Mr. G.N. Sahwal, the learned counsel appearing on behalf of the respondents. The instant application has been filed under Article 227 of the Constitution. For setting aside and quashing the orders dated 10/2/2021 passed by the learned Munsif number 1 Dibrugarh, hereinafter for short referred to as the trial court in title suit number 4/2019, whereby the counterclaim filed by the petitioner was excluded. Further to that, the petitioners have also assailed the order dated 2/3/2022, by which the review filed to the order dated 10/2/2021 was set aside, was rejected. Full stop. This court have duly taken note of have perused the copy of the plaint in title suit number. What is that title suit number?
Case number 4 of the 2009.
Title suit number 4/2019. Full stop. A perusal of the said plaint reveals that the plaintiff, who is the respondent herein, have filed a suit for eviction of the defendant as well as for recovery of area rent. The record further reveals the written statement was filed along with a counterclaim. denying the grounds on which the suit was filed, as well as also seeking a declaration that the defendant is not a defaulter, and seeking adjustment of her dues or expenditures on account of new construction of the suit premises with the monthly rent of 1067 rupees 1067. Full stop. This court have also perused paragraph 6 of the counterclaim.
Another aspect is there, in the counterclaim, it says that once Yamadevi claims to be owner, and he has given part.
Okay. Paragraph 6 have also perused paragraph 6 of the said counterclaim, which also wherein it has been stated that the value of the counterclaim is rupees 2 lakhs. So, considering the above, this court have also perused, taken note of the provisions of Order 8, Rule 6A of the Code of Civil Procedure, and is of the opinion that in the present facts of the case, the learned trial court ought not to have rejected the said counterclaim and directed the respondent, the petitioner herein, who is the defendants, to file separately, to file a separate suit. The said would only amount to multiplicity of proceedings, which is not in the interest of justice. Considering the above, this court sets aside the order dated 10/2/2021, whereby the learned trial court rejected the counterclaim of the petitioner, oblique the defendants, and directed the defendant to file a separate suit. Further to that, the order dated 2/3/2022, by which the counterclaim was the review to the order dated 10/2/2021 was rejected, being consequential, is also set aside. This court have also heard Mr. G.N. Sahiwala, the learned counsel appearing on behalf of the senior counsel appearing on behalf of the plaintiffs, who submitted that on account of the present proceedings as well as the filing of the counterclaim, there has been a delay in disposal of the suit for recovery. This court is of the opinion that this court having taken the matter and its entirety is of the opinion that a request can be made to the learned court below for disposal of the said suit at the earliest, and preferably within a period of 1 year from the date of submission of the certified copy of the incident proceedings, 1 year from the date of appearance of the parties. This court have also taken note of that on 8/8/2022, the proceedings of the suit was stayed by this court. The stay order is vacated, and the parties herein are directed to appear before the trial court on March 19th, 2024 for further proceedings of the said suit. With petitions, proceedings stands disposed in terms with the observations. With the above observations and directions.
Item 6.
Yes, what is this?
My lord, petitioner is the defendant, your lordship. And at the stage of cross-examination of DW 2 and 3, your lordship, petitioner submitted a petition saying that due to illness they could not appear at on that day, and it was rejected, and case was fixed for argument.
How many times you have taken adjournments for DW 2 and 3?
Prior to this, 3 times. I have taken.
So, matter is over. You don't get to
My
move.
lord,
much.
at all the
There's
appeals,
nothing wrong with this order.
my lord, impute order is at page
Sorry,
43, my
absolutely nothing. This is a case for dismissal right away.
My lord, we have submitted our
You
written
can't.
statement
How
in-
many times you are the defendant?
Yes, my
When did the defendant evidence start?
lord. My lord, prior to this, your lordship, all the dates we have submitted petition with ground, your lordship, and all were allowed, your lordship. Only we are seeking for one,
Sorry.
my lord. My lord, we have, my lord, kindly see page number 43, your lordship.
Not necessary.
My lord, order itself,
When was the date of defendant evidence started?
my lord.
The instant proceedings under Article 227 of the Constitution has been filed, challenging the order dated 16/8/2022, passed in money suit number 68/2021, wherein the affidavit, wherein the evidence of DW 3 and 4, 2 and 4 was expunged from the record, and the evidence and the further evidence of the DWs was closed. The court, the learned trial court, that is the court of the Munsif number 2, Mongoldoy, had fixed 29/7/2022 for arguments. This court had duly perused the order sheet of title suit number, money suit number 868 of 2021. And it is seen from the records that from 1/4/2019, seen from the records that 1/4/2019, the case was fixed for, on 1/4/2019, the case was fixed for cross-examination of the DW1 to DW4. Full stop. Thereupon, on account of the cross-examination of the DW3 and 4, 2 and 4, the case has been fixed since 23/7/2019. And there, the record further reveals that on various occasions, time has been taken. Considering the above, this court does not find any good ground for exercising the jurisdiction under Article 227 of the Constitution. Consequently, the instant proceeding stands dismissed. Full stop. The further proceedings, the interim order dated 23/9/2022, passed by this court, is vacated, and the parties herein and the trial court is directed to proceed with the disposal of the suit on the disposal of the suit. Disposal of the suit. A copy of the instant order, which the registry is directed to serve furnish a copy of the instant order to the learned court below.
May I submit one thing, my lord? My lord, though case was fixed for DW from 2019, my lord. From 2021 onwards, your lordship, we can see from the records, your lordship, due to COVID, your lordship, the suit was pending, and thereafter, because the suit valuation is more than 3 lakhs, my lord, so it was transferred to Munsif, my lord. Because of that, your lordship, my lord, at the for 1 year, it was in the transfer from
Orders were very clear. Court cross-examination of DW2 and
from yes,
nothing. You have got its own.
public.
Yes. What is this?
Okay.
Seven.
Wait, your lordship.
What are you challenging?
The petitioner before your lordship is the decree holder in respect of a plot of land, my lord. Land was enforced by the defendant, judgment debtor, and decree was passed in my favor, declaring my right title in interest over the schedule A schedule land, and out of that A schedule land, schedule B was encroached about 8 lessons. Decree was passed in my favor for first position in respect of schedule B. Decree is at page 33, my lord. My lord, what had happened when the execution case was started and executing party proceeded to the fruitland. But without execution, the report was given by the Nazir that execution has been complete. Then, my lord, the decree holder, being an illiterate person, is gullible, my lord. He was gullible. He was asked to put his signature on some paper, revenue stamp paper. He put his signature. Then when nothing was done, he made an inquiry in the office of the Sadar Munshi, and he was told that you have nothing to get because you have put your signature and the execution has been carried out. So he filed an application before the learned Sadar Munshi that I was asked to put my signature. I put my signature, no doubt, but I was told, I was persuaded this is required. It is to be submitted before the court. So because of his putting the signature, the learned Munshi was not pleased to entertain his prayer for making an inquiry. The order is at page, my lord, 51, Annexure 9.
Okay. But madam, tell me one thing. Your decree has been passed for right title interest, recovery of possession, as well as for permanent injunction. Okay? So irrespective of anything, if the permanent injunction, if a person is not given you, they have shown that particular land, you have signed it also. Then also, a permanent injunction can be very well, there is no limitation for that. You can very well ask for again enforcing the decree, isn't it? Yes, who is there?
I'm there, my lord.
Why is it not permissible?
Yes, Your Honor.
Why is it not permissible? You see, the decree is for right title interest, recovery of past possession, as well as for permanent injunction. Now, if you are again in possession of that, why can't she very well ask the court below, then look here, whatever may be, rightly or wrongly, he has put the signature or not. If the property has been already identified by the, then why not the permanent injunction prayer, which the decree can be very well enforced to that same execution proceedings?
My humble submission being, Your Honor, the decree was executed by the Nazir of the court with assistance from the police, with assistance from the Lakmandal. The village head was also present. So the allegations that was raised in the application under section 151, these are very serious allegations. Allegations against police officials, government officials, court officials, and to a certain extent, maybe on the executing court itself. All these allegations, to decide these allegations, Your Honor, these are serious in nature. To decide these allegations, my humble submission being, Your Honor, maybe the application under section 151 is not maintainable. Evidence has to be adduced. Supposedly the execution...
So therefore, should the court directed them to file an evidence? Then why did the court dispose it of?
Yeah, they preferred hearing. They did not pay before the trial court to adduce evidence.
But irrespective of all these things, here is a case, his basic contention is what? that look here, this is the area which has been found out, this is the suit land. You say that this is the suit land, there is no quarrel with that. The second aspect comes in is that the Nazir says we have handed over the possession.
Yes, Your Honor.
And thereupon what has happened, we don't know. Your thing is, or if any further thing has happened, there is a violation to the permanent injunction decree.
Yes.
And if there is a violation to the permanent injunction decree, there is no limitation. It can, or it's a continuous decree.
Very true.
So under such circumstances, why the court, in spite of that, didn't ask the Nazir to look into it? Yes, who is in possession? Because now the permanent injunction, because I think when she filed an application, she also asked for the execution as regards the permanent injunction.
One humble
Why
suggestion, Your Honor.
didn't the executing court look into that aspect of the matter?
Well, there is also a decision for this honorable court,
Only-
my lord.
I don't require decision.
I'm basically not affected. by this.
We would not touch on this, but we will ask the executing court to execute the permanent injunction aspect if it is not there.
So far, that is concerned, that is true, Your Honor. But the allegations cannot be presumed to be true.
Whatever the allegation, right or wrong, whatever allegations, let us not go into those
Yes, Your Honor.
niceties. We go into directing the executive court to take that application as an application under an application for violation of the permanent injunction and thereupon to decide. That is, because after all, the fruits of a decree cannot be set aside just for the sake of it.
May I bring to Your Honor's notice one simple aspect, Your Honor?
Yes.
Your Honor may kindly peruse paragraph 10 of the revision petition.
What is that?
May I read it out, Your Honor?
Mm.
That the petitioner, after obtaining the copy, submitted an application before the learned executing court on 8/8/2022, it ought to be 2022, contending inter alia that the decretal land, the house, establishment, etc. of the judgment debtor are still there till that day, and the Nazir and the court have not acted in compliance with the warrant of possession. There is great injustice as well as loss, and accordingly prayed for an inquiry. So an application was filed. Application was filed on 8/8/2022. Then paragraph 11, my lord, that the petitioner humbly states that the learned court having not been available, then the said petition remained pending and could not be moved. However, the petitioner filed another application afresh in November 2022 with the same averment made in the former petition. This is a subsequent petition.
The court was not available.
Let us not go into all this. The instant application has been filed under Article 2 to 7 of the Constitution, challenging the order dated 22/12/2022, passed in title execution case number 9/2000. What is the
20,
number?
my lord.
2020. Whereby the learned
I know.
executing court, that is the court of the, what is the court? Which court is this?
My lord.
Learned executing court, that is the court of the Munsif number 1 at Nalbari, had rejected the application, had dismissed the application filed by the judgment debtor. From the perusal of the record, it reveals that the petitioner herein had filed a suit, being title suit number 2032/2016, seeking for declaration, recovery of khas possession, injunction, and other reliefs. The said suit was disposed of by the judgment and decree dated 10/12/2018, whereby the learned trial court had decreed the suit on whereby the learned trial court declared that the plaintiff has the right, title, and interest over the Schedule A land. It was also declared that the plaintiff is entitled to recover the khas possession of the suit land by evicting the defendant and his men and agents therefrom by demolishing the illegal construction made by the defendant thereon. Further to that, the defendant and all men and agents were permanently restrained from interfering with the peaceful possession of the plaintiff over the suit land or from making any claim over the suit land after the delivery of khas possession of the suit land to the plaintiff. The said decree was put to execution by filing an application. And on the basis of which title execution case number 9/2020 was registered. Full stop. On the basis of the writ of delivery of possession which was issued, it is the allegation of the petitioner that the entire land was not handed over to the petitioner. On the other hand, the Nazir and the other authorities have misled the petitioner to put the signature, and this aspect of the matter was brought to the attention of the learned executing court by filing an application under 151. On the other hand, the learned counsel appearing on behalf of the respondent, who were the defendants, had submitted that the land was duly executed, the decree was duly executed, and thereupon the signature was taken from the decree holder, that is the petitioner. Full stop. And as such, there is no illegality in the order impugned in the instant proceedings. This court have duly heard the matter and have given its anxious consideration to the issues involved. Full stop. The fact that this court have duly taken note of the decree which has been passed, and a perusal of the decree, it reveals that the suit was not only decreed as declaring the right, title, and interest and recovery of caste possession of the Schedule A land, but also there was a decree for permanent injunction to the effect that the defendants therein could not have interfered with the peaceful possession of the petitioner over the decree holder over the suit land after the delivery of caste possession. Therefore, the question arises as to whether, even assuming the decree was duly satisfied by handing over the possession, then also the question of compliance to the decree for permanent injunction was required to be investigated upon by the learned trial court, by the learned executing court, which, however, is not seen from the impugned order dated 22/12/2022, whereby the learned trial court had assumed that upon the delivery of caste possession, the entire decree stood satisfied. Considering the above, this court therefore sets aside the order dated 22/12/2022, directing the executing court to take the application to decide afresh the said application, treating it to be an application for the purpose of compliance to the decree for permanent injunction. Taking into account the parties are before this court vacates there's a stay. This court, taking into account that both the parties are before this court, the parties are directed to appear before the trial court or before the learned executing court on 23/2024, on which day the learned executing court shall further proceed with the execution case, giving thereby passing appropriate orders as deemed fit. With the above observations and direction, the petition stands allowed.
Item number 8.
Yes. What is this matter?
My lord, there are two judgments, Martia and Transfer, saying that two proceedings can go simultaneously. SARFAESI as well as section 19 and section 17 of this, they can go simultaneously.
Section 19?
Section 19 of the RTNP Act.
DRT.
And section 17 SARFAESI. Now these two can go simultaneously. By judgment, it makes it very clear. Why I have approached this normal court under Article 220? Instead of going to DRT, that's the question your lordship will ask. That there is a procedure against any order passed by recovery officer or DRT. Now the case, what it will is that they are we are proprietor firm. Number 2 is the guarantor. 1 and 2 is the guarantor of a property, ABC property. It has been mortgaged to the bank. Now, we could not repay the amount. 1 crore something we could not repay the amount. They proceeded within the OA under Section 19. Now, OA proceeded, decree was passed, certificate was issued. Then recovery certificate also processed. Before that, they decided to proceed under SARFAESI. 2 notice was given. Now, we challenged these 2 notice before the DRT. 2 notice before the DRT. Our whole case before DRT was that issuing of the notice under 13.2 and 13.4 is bad because that procedure has been violated. The matter was taken up by the DRT.
So you proceeded, you challenged the proceedings in the DRT under 17
Yes, correct.
under on the base in respect to the actions taken under 13.4.
Right.
Then
Right. Now that matter was taken up by the court. Now, in the meantime, OA decree was, the certificate was issued and the recovery RC also, recovery certificate. In the meantime, what has happened, they issued a notice, either you pay it or we will go for attachment. Now the property
this is done by
by the
under the
recovery
SARFAESI.
no, by the recovery officer.
Okay.
By the recovery on the basis of the OA. So they went ahead and they issued a certificate. Under the basis of the certificate, they said either you repay the amount or we will go for attachment of the property. Now, what they have done, recovery officer went ahead for attachment. Even the property was with them very much, and they were under physical because by SARFAESI they took over the property, and they have taken the property in physical possession. Physical possession also was with them.
Under the SARFAESI.
Under the SARFAESI. But they have gone ahead and said that we want to go for attachment, thereafter proclaiming. We filed an application before the DRT and before the recovery officer. We said, please stop it here because already that proceeding SARFAESI is going ahead. That will be decided by the court, DRT court. He didn't go. Fine. He rejected the application. In the meantime, 4th of January 2023, that was the order which the matter is decided by the DRT on SARFAESI. And SARFAESI quest the entire proceeding under 13.2 and 13.4.
So SARFAESI proceedings.
And they are directed by 2nd of February 2020 to return the possession back to them. That was the direction passed. Now, against that, my lord, they went to DRAT, and that is in state. Now, recovery officer wanted to proceed by way of an auction. Against that, we have come up before this.
So the moment the DRAT stays,
Yes.
the proceeding
Then it
of the
then
SARFAESI, again the possession is back to
possession
the
is back. We cannot, because
the bank.
until and with the bank. Possession was already with them only.
Now
So
understood, but there was a direction on
Yes,
2nd of February
yes,
to hand
there
it
is
over.
Option of returning back because there is a stay. There is a stay
Now
by DRAT. So it's it's fairly back goes back to them only. Now the bank we appeared before DRAT. The matter is pending. It is being taken up on 21st, I think, of this. That's a separate altogether. Now the question before your lordship is now the point which I raised under 227 is that number 1, when the SARFAESI proceeding is going on the same property and 2 simultaneously can go ahead. Now what happens when it reaches to a loggerhead? Because of the same property which is being questioned before the DRAT and also before recovery officer takes the same question.
I think the best option would be to await the outcome of the DRAT.
Correct. This is what we said. So
What do you say?
No, my lord, my question would be, your lordship kindly see.
Now you are in
Order
possession.
telling-
Are you in possession?
Yes, yes.
You are in possession.
Yes.
Now, on one hand, you are in possession. The proceedings have been stayed. The proceedings of the DRAT, setting aside the entire proceedings, have been stayed. So thereby, again, it is back to you.
That is under SARFAESI Act, my lord.
Understood. SARFAESI Act. Now, in respect to the same, isn't that the property which is also the subject matter before the recovery proceeding?
My lord, it's the same, but the question would be whether this 227 application is maintainable at all.
My lord, there is a provision under DRT Act under section 30. This order ought to have been challenged there. And my lord, there are so many discussions with the appellate court. I will take your lordship subject if your lordship is allowed. Now, if there is a certain provision, statutory provision, my lord, you will have to go there because these provisions are very substantial in nature. Even, my lord, supposing I take possession of the land illegally, my lord, the provision in the statute is that they can put the clock back. It means that status quo ante will have to be maintained. My lord, the appellate court time and
No,
again.
no, tell me one thing. Understood. Rehearse this proceeding. How is the recovery officer going to act or attach the same property which is there in your possession?
My lord, the question is, since it is stated by the DRT, now this property which we are going to get it back, I mean, after auction sale, this is the order which they have challenged. On the other hand, your lordship kindly see, they are not challenging other orders. On 28/11, if your lordship take it,
No, no,
why?
Mr. Dutta, kindly tell me a very both the cases, the property is the same.
Same.
In by virtue of 13(4), you have taken the possession.
Yes.
Now, DRT recovery officer, what does he want to do with that property? He wants to attach.
At sale in auction, man.
No, he wants to first attach
Attached, yes.
and
Attachment
then
has-
sell in auction.
it is already been attached.
Okay.
It is-
Now
it is
they want to sell in auction.
Auction, yes.
Okay. What is stopping you from selling it in the auction in terms with the earlier property?
No, because
You are already there because that proceedings have not been stayed by the DRT.
that is not, but this honorable court passed an order.
No, this okay. We will look into it.
My lord.
Here, the court order is only as regards the recovery proceedings. The stay is only as regards recovery proceedings.
We are giving test on the recovery proceeding. My lord, the order passed by the DRT issuing a recovery certificate.
You want to
After that-
forego because there is a question of doctrine of election.
Yes.
At one point of time, because the property is the same,
property
you
is
want to
same.
go this way or that way, whatever may be. There is no quarrel. Both the proceedings
Simultaneously can go.
simultaneously can go, but
Right.
when it reaches a point by which both the proceedings have already been decided, and now the question is where to go, is whether to take up these proceedings for taking up this money, or do I take the that proceedings for the taking up the? Because as of now, if the proceedings under the DRD, the SARFAESI has been stayed, the order by which it has been set at naught has been stayed by the DRT,
DRT.
thereby it comes back to the same position today. That means you are in a position to exercise the powers under 13(4).
My lord, we are not going to 13(4) now. We are in DRT proceeding. Certificate has been
So you
issued.
have to then forego 13(4).
And the follow, we may forgo at time.
No, you can't go at one point of time. Then only this court can do anything.
My lord, only thing, my lord, foregoing that SARFAESI action is no problem for us. Only, my lord, one thing troubling us. Your lordship may look at 19, 19, recovery. Your lordship may kindly see section 19 of SARFAESI Act.
Just before that, I'm sorry for troubling my learned friend. Before that, kindly see doctrine of election, that's what stand they have taken before the DRT. Section 35, doctrine of election, false election. You have to choose either of it. What your lordship, page 68, they have choose, but they have gone. CHP, kindly see 68, page 68. Third paragraph, kindly see 68, third paragraph. Third paragraph, CH further stated three property mentioned schedule so and so under possession under SARFAESI, and these property have been attached by the learned tribunal by order rated so and now CHB has decided to withdraw recovery proceeding under so and to proceed further under so and. But they have gone ahead before DRT and this has been stated.
Well, can I propose one thing, my lord? Your lordship kindly see section 19 of the SARFAESI Act.
Yes.
Right of borrower to receive compensation and cost in certain cases. If the debt recovery tribunal of the court of district judge on an application made under section so and so or the appellate tribunal or the High Court on an appeal preferred under section 18 or 18A holds that the possession of secured assets by the secured creditor is not in accordance with the provision of this act and rules made thereunder, and direct the secured creditor to return such secured assets to the concerned borrowers or any other aggrieved person who has filed the application under section so and so, or appeal under section so and so, as the case may be, the borrower or such other person shall be entitled to payment of such compensation and cost as may be determined by such tribunal or court or district judge or the appellate tribunal. Now, what I am suggesting, my lord, if your lordship gives the party to withdraw that SARFAESI proceeding, provided that your lordship says that the compensation which they can ask under section 19, that may not be gone into. In that case, that proceeding we can withdraw. In fact, we filed an application before the tribunal. The tribunal said you cannot do that. You can
Because your only worry of going there is that if it is held, they will be entitled to compensation.
My lord.
That is the only worry.
Yes, that is the only worry.
So file it on affidavit.
Yes, that
Bring
we
it
can
on
do.
affidavit.
My-
Because once you bring it on affidavit, you
That-
take your call then.
Yes, yes.
My lord, let it
100%.
come
We have to take it
after a
forward.
week, my lord. I'll
Very well. We'll have it when?
beg your pardon.
When?
After 1 week, any date convenient to your lord. I believe your lordship is there for another 1 week.
Huh?
So it is taking up, let it be parted. Your
No,
lordship-
Yes,
no, I don't have
Are you-
partner.
No, your lordship,
Partner
If it is not
I'll
inconvenient,
be
I don't
quite
make
happy. Your
anything
lordship.
partner.
if it is not
Didn't you
inconvenient,
see I have taken up that bench pipe
No,
matter
but
for a
if-
long time.
but
Then
if
also I left it.
My lord,
If
it
it is not
becomes
inconvenient.
easier for us before your
no,
lordship
because they are
because
achiever,
Huh?
your lordship get the thing very quickly. That's
No,
it
no,
becomes
it
easier
is
for us.
not required.
we don't have to do much of homework. My lord, it can be, if it is not inconvenient.
When are you filing? I'm here for I think I'm taking up this bench for 2 weeks, I think.
In that case,
How
it's
long
okay.
they have given?
Just a 1 week time, your lordship may fix it.
I'll record it in the order.
Yes,
This
yes,
respect.
definitely.
Heard Mr. Dida, the learned senior counsel, is appearing on behalf of the petitioner. And Mr. S. Dr. the learned senior counsel appearing on behalf of the respondent number 2 and 3. The instant proceedings have been filed challenging the orders dated 6/10/2022, 10/11/2022, 28/11/2022, and 1/2023. Passed by the respondent number 1 in RC number 66/2022 arising out of OA number 99/2018. And also for quashing of disorder. The brief facts which can be discerned from a perusal of the proceedings before this court is that the petitioner herein had taken a loan from the respondent number 2 bank, and an amount of rupees 1 and of bank, and thereby mortgaging, creating interest, thereby mortgaging various properties. Full stop. Against the said amount, as the petitioner had defaulted in payment of the said amount, a proceedings before the Debt Recovery Tribunal Guwahati was initiated, being OA number 99/2018. By the judgment and order dated 4/8/2022, the learned Debt Recovery Tribunal issued a certificate of an amount of rupees 1,28,73,164.61. Full stop. Thereupon, the recovery proceedings was initiated before the respondent number 2. While the said proceedings was initiated, the petition, the respondent number 2, before the respondent number 1, before the respondent number 1. While the said proceedings were pending before the respondent number 1, the respondent number 2 further initiated proceedings under the SARFAESI Act 2002, for short, the Act of 2002. The respondent number 2, while initiating the proceedings under the Act of 2002, further went ahead and took up action and took actions under Section 13(4) of the said Act of 2002. These proceedings under the Act of 2002 was put to challenge by the petitioners under Section 17 of the Act of 2002. It is very relevant, it is very pertinent herein to mention that when the proceedings was initiated under the Act of 2002 by the respondent number 2, they had taken physical possession of the properties in question. At that stage, an issue arose as to whether the recovery proceedings could be continued by the respondent number 1, taking into account that the respondent number 2, for whom the said recovery proceedings have been initiated, is in physical possession and are taking actions under the Act of 2002. Under such circumstances, an application was filed by the petitioners before the respondent number 1 for keeping in abeyance the said recovery proceedings. While the said application was filed and was pending, in the other proceedings initiated under Section 17 of the Act of 2002, the Learned Debt Recovery Tribunal held that the proceedings initiated under Section 13 of the Act of 2002 upon the petitioners was illegal?
Yes.
Illegal and directed, handing over back the possession. Being aggrieved, the respondent number 2 thereupon approached the Debt Recovery Appellate Tribunal against the said order passed in the proceedings under Section 17 of the Act of 2002. The Learned Debt Recovery Tribunal admitted the said appeal and stayed the order dated. What is the date of that order?
What's the date of the order?
Had stayed the order dated
16/2.
of the
16/3
recovery,
of-
the DRT.
DRT. What's the
What is the DRT's order?
DRT of DRT 4/1. DRT. That means surface date is request 4/1/2020.
4/1/2020. On the other hand, in view of the stay being granted by the Learned Debt Recovery Appellate Tribunal,
It has been stayed on 16/3/2020.
by the order dated 16/3/2023,
Maybe 15/2/2023.
15 by the order dated by the Recovery Tribunal dated Recovery Tribunal
15/2. Sorry, 15/2.
15/2/2023. The situation again came back to the status of the property again stood restored back to the stage prior to the passing of the order by the Debt Recovery Tribunal dated
4/1/2023.
4/23. And thereby the respondent number 2 continued to hold physical possession over the properties in question and had the right to further continue with the SARFAESI proceedings. In the meantime, while those proceedings were going on, the respondent number 1 passed the impugned orders whereby to further proceed with the execution of the recovery certificate by passing various orders, which is now the subject matter of the present proceedings.
Some factual correction.
Yeah.
Has been actually order has passed before passing of the order of 4/1.
Understood. That is why I use the word in the meanwhile. In the meanwhile means in the meanwhile
That
from
will-
there to there. This court have heard the learned counsels appearing on behalf of both the parties. And a specific pointed query has been made to Mr. S. Das as Dr. the learned senior counsel appearing on behalf of the respondent number 2 as to when the very property is with the possession of the respondent number 2 and the respondent number 2 can further proceed in terms with the SARFAESI proceeding under the Act of 2002. What was the necessity for the recovery officer to again further proceed for recovery on the basis of the same by putting on sale the said property? It has been submitted by the senior counsel that the recovery proceedings, the proceedings before the recovery officer is what the respondent number 2 wishes to proceed with. And the appeal has been filed challenging the order dated 4/1/2023. So that the consequential effect of this, the consequential effect of the order dated 4/1/2023 would not subject the respondent number 2 for certain damages on account in terms with section 19 of the Act of 2002. He, however, submitted that if the petitioners forego any claims in terms with the under section 19 of the Act of 2002, the respondent number 2 would not further persist with the proceedings under the Act of 2002, but rather proceed with the recovery proceedings on the basis of the certificate so issued. Taking into account the same being on the basis of verbal instructions, this court is of the opinion that the same is required to be put by way of an affidavit so that further consequential directions can be passed. Mr. S. Dottas, the learned senior counsel, upon instructions 6 a week's time for filing such affidavit. List the matter again on 15th of March.
Yes.
Can it be on 12th?
12th is Tuesday.
Let it be 15.
These matters are not for Tuesday.
Your Lordship will be very free on that. Your Lordship will be a bit free.
I'm already done. I'm telling. We'll have it on 13th. Don't want that unlucky number.
No, 13, no problem is there. Can it be on 15?
Let's be on 15th. 3 and 15. You do one thing. You file it by 12th,
Yes, yes. Take
and
care
if
of
any
it.
reply he has to submit, he
Well-
can do it by 15th.
Well-
This is the matter on 15th of March. The respondent number 2 bank shall file the affidavit on or before 12th of March. The petitioner, if so advised, would be at liberty to file the reply by 14th of March.
Then the interim order.
In time order past earlier shall continue. till the-
Much of it.
Very big. But if we find the judgment at page 112.
Then
Judgment is at page 112. So the defendant or the respondent here is they have filed the money suit for realizing up to
how much?
2 crore 77 lakhs.
Then
We'll file the written statement and the issues were framed. Logic will find the issues at page 120. Page 120. The issue number 3 and 4 and 5. 3 as regard limitation, law of limitation, and 4 as regard the entitlement of the plaintiff. It was decided to the extent of 39.
Then
Because of repeated, that's why repeated reminders, they
there's an I. Then there is an I. Interlocutory application.
so well, I
There is no stay.
I have made a prayer.
You can't make a prayer like this. Then under the provisions of Order 41, Rule 1(3), why we shouldn't dismiss your petition?
But I'll
You have to file an I.
but I'll
It's not a read.
order 41 that I'll file.
Okay, Mr. Mr. Tina appearing on behalf of the appellant, 6 weeks time for filing an interlocutory application under Order 41, Rule 5 of the Code of Civil Procedure 1908. This matter date 13th of March. File your application. 50% has to be paid. That is also another
Lordship.
thing.
Lordship, the admitted amount is more than 50%. I will show you, Lord.
That is immaterial, but that is the rule.
Admitted otherwise.
Yes, what is this?
Lordship, we are agreed by an order, my lord. Lordship will find at page number 34, the petition. Therefore, my lord, we wanted to produce an additional witness after cross-examination of some CPW. That has been rejected.
What did you want?
My lord, there is a mistake in the, I would say, my lord, the exhibits were not, documents were not exhibited while reducing those witnesses, my lord. So on conclusion of this, my lord, the Learned Counsel appearing on behalf of the petitioner, he made an application that was rejected, my lord, which your lordship will find at page 34.
Thereafter, my lord, we'll file on the next date, we filed an application. My lord, we have engaged another set of counsel, my lord. That application was also rejected. That order lordship will get at page number 40, annexure 9.
Then,
My lord, we are agreed by both these orders, my lord. We may be allowed one opportunity to bring an witness, my lord. Otherwise, the revocation petition, my lord, succession certificate was granted wherein we were not made party earlier. So we filed an application under 383 Succession Act for revocation of the succession certificate. But if these documents, which were listed at the time of filing the petition for revocation, are not brought on record, my lord, then our grievance will fail, my lord. So
why
one
didn't you
opportunity-
bring it at the first instance?
Well, that's, my lord, I maybe.
Cost, allow it with a cost of 50,000.
My lord,
Yes, Mr. Ejda.
Yes.
We allow it with a cost of 50,000.
Otherwise, flood
Unnecessary
second
delaying
wife.
matters doesn't help.
no, my lord, regarding cost part, my lord.
60.
My lord, the grade 4 employee has been, my lord, who expired.
So what? If you can wait for, you can't take the people for right. And another 10,000 for here, unnecessarily delaying the matter. 50,000 cost. We allow it because one has to see the justice. Why didn't you at the first time grant submit your documents 1, 2, and 3, and then you make an oral submission? You want to put the clock back on the basis of an oral submission, and then after fixing it for DWs, you never said anything. You made a US in 2021. From 19 to 2021, you submitted all your chiefs. Then, and one fine morning, you want another one. Very well. Then pay.
But, my lord, it may be considered, my lord, in that while filing the original application for revocation, my lord, these documents were there in the record. We placed it, my lord.
Original,
Original documents that we want.
were there.
Yes.
Then why do you need the PW4? Do require.
Well, that has to be.
We'll direct it. That okay, if the documents are already there, then you can exhibit it. I'll give you an additional opportunity. That's all
Yes, my
for
lord.
exhibiting.
If lordship allows us,
If you can't produce any further document. You can't produce any further document. These documents are in original being there. You are going to only given the idea to exhibit. Nothing more than that. Are you agreeable for that?
see those documents, my lord, there are documents. Yes, my lord, that can be done, my lord. Otherwise,
That's the only thing.
yes, sir.
Okay.
If my lord,
You may be given an opportunity for tendering PW1
one PW.
PW1 for giving an additional evidence on the documents which are already there, if in origin.
Yes, my lord, record has been called for. It is
Why do
there.
you need the record? Huh?
But you will find those in revocation case number 1 of 20.
What do you want to exhibit?
One nomination paper where the present petitioner has been appointed the nominee.
You
in
want
the
to bring
pension
on record the certificate of death,
death certificate and certificates of
the transfer certificate,
of funds.
Director of Health Service, registration certificate, affidavit.
And my lord, one pension nomination paper is there. It is lying with the
Pension
office.
nomination is this one, affidavit.
No, my lord, one Xerox of that office file is there.
Huh?
One Xerox copy is there whereby the present petitioner has been nominated as nominee of the pension process.
Where is that photocopy?
There, my lord, along with that.
Now record from the. Click on video. Tap on video. And click on text mark which you want.
Follow that page 45. Page 40.
Where is your chief?
Here I have not, along with this, while filing this, if you are not close.
Then this petition which is filed on 16/6/2023. This is the petition on which you have enclosed the original after the order has been passed. Isn't it?
No, my lord, in the, at page 26, my lord, at page 26 of the revocation application, these are the documents they say they have enclosed. along with-
Mr. Counsel, I had practiced so many years in the trial court, so I know how it is. This petition on 16/6/2023, after filing of the writ petition before this court, you filed it. On that day, you enclosed these documents. These 5 documents. These were not documents which were there at that point of time. Okay?
Yes,
Isn't it?
sorry,
So why you are saying that these documents were already there before?
my lord, that That's why, my lord, page number 26, my lord, from that I am saying, page 26 with the petition that they have filed,
Page 26 of the
is the revision petition. It is the application which they have filed, my lord, for revocation.
Hmm.
There, my lord, and list of documents and close.
Understood. These originals were not there at that point of time. Then why you are saying that? So why you are misleading this court?
So, my lord,
Yes. You filed these documents at a subsequent stage. The 50 plus 20 as from you. Cost.
no, my lord,
20 from you. From you. What's your name?
my lord, I am here, sir.
Okay. From PR, sir.
My lord,
Yes,
that's not, my lord. I am
20,000
submitting
from
on
you.
the basis of this, my lord, the application.
No.
they have.
After the order has been rejected, then you file this application on 16/6 along with a copy of the order before this of this court. Because this petition was filed on 30/5/2023. This petition before this court. And the order which had been passed by this court, on the basis of that, the further proceedings were stayed 5/6/2023. And then you file this application on 16/6/2023, enclosing these 5 documents.
So that I am not aware, my lord. That subsequently they have, my lord. I have
Then-
whatever I have. submitted, my lord.
Then okay, then we are to construe. Are you going to take up like this? That all the documents you can only, I'm giving you the opportunity
Yes, my
of only the original documents which are not on record prior to 16/6. Would you be comfortable with that? Because the record does not
My
there.
lord, I will be comfortable with page 26, my lord. This is right from the day one, my lord. I am submitting that I have.
These documents were not there in original before the court.
This is the certified copy of the I was provided, my
These
lord.
are not original documents. These documents were placed before the court on 16/6/2023 by this petition.
I am, believe me, my lord, I am not aware of.
So,
these
okay, then
subsequent
we
decisions, my
reduce
lord.
the 20,000 from you, if you are
My
believing
lord,
it.
From the day one, my lord.
But
I am
remaining
saying
is 50,000. 50,000. That is the only way out. You have made the mistake all
Yes,
this
yes.
while. Now, with these documents, if I am allowing you, then the question is, he will have to cross-examine you, this
Yes, my-
document.
yes, he will cross-examine.
Now, isn't it again another stage of cross-examination comes in unnecessarily and thereby delaying the proceedings? Yeah. We get in PW1. PW1 is the petitioner.
Yes.
I allow her to give the evidence, price evidence on affidavit enclosing the original documents. That is it. Subject to deposit of 50,000. The instant petition has been filed under Article 2 to 6 of the Constitution, challenging the orders dated
227.
2 to 7 of the Constitution, challenging the orders dated 4/2/2023 passed by the learned District Judge Walpara in Miss Revocation case number 1/2020, in Miss Succession case number 27/2018. From a record, it reveals that the petitioner herein claims to be the legally wedded wife of one late Dharmeshwar Rabha, a grade 4 employee. One Dharmeshwar Rabha, since deceased, who was a grade 4 employee in the establishment of ASO Motia Revenue Circle. Her husband expired on 24/4/2017. Subsequent that after the demise, it is the case of the petitioner that the respondent, by misleading, had filed a mis-succession case number 27/2018 to the effect that late Dharmeshwar Rabha used to reside at Bogdhabi, Krishna at the time of his death, and the deceased had no other legal heirs except those as mentioned in her petition, that is, mis-succession case number 27/2018. On the basis thereof, the learned district judge had issued a succession certificate on 23/9/2019, pursuant to the order dated 22/8/2019. This succession certificate was challenged by the petitioner by filing a mis-revocation case number 1/2020. During the said proceeding, the petitioner examined 3 witnesses, including herself. However, on account of legal advice, the petitioner did not submit the original documents at that relevant point of time. Subsequent thereto, upon change of counsel, the petitioner did not submit that. In the meantime, without submitting the original documents, the examination of the witnesses on behalf of the petitioner was complete. Subsequently, on account of the change of counsels who advised that there was the requirement on bringing on record the original documents, an application was filed which was rejected. And under such circumstances, rejected by the impugned order dated 4/3/2012, 4/2/2023, which is the subject matter of the instant proceedings. This court have duly taken note of. This court have duly perused the file, the lower court records, which were called for by this court. And from a perusal of the said lower court record, it reveals that only after the orders impugned in the proceedings have been passed, an application under Order 7 Rule 14, read with Section 30 of the CPC, was filed to bring on record those original documents. However, the said application still remains pending, taking into account that in the meantime, on 30/5/2023, this court, the petitioner herein had approached this court and an order was passed on 5/6/2023, staying the further proceedings of the said mis-revocation case number 1/2020. This court have duly heard the learned counsels appearing on behalf of the parties. It appears from the perusal of the materials, that the original documents were not enclosed at the time of submission of the evidence which the petitioner ought to have done. However, this court cannot be unmindful of the fact that the petitioner is a widow and may not be aware of the legal niceties of tendering the original documents at the time of evidence at the time of filing the evidence on affidavit. The lawyer who was engaged ought to have properly guided the petitioner in doing so. Under such circumstances, on account of the fault of the petitioner, on fault of the lawyer, the petitioner cannot be penalized, taking into account that those documents have a vital relevance to the adjudication of the proceedings. Considering the above, this court is of the opinion that the interest of justice would be met if the petitioner is given an additional opportunity to bring on record those documents which were filed along with the petition on 16/6/2023. By adducing additional evidence. Consequently, this court, therefore, directs the learned court below, directs the learned district judge, Gwalpara, to permit the petitioner to submit an additional evidence on affidavit by herself, thereby to adduce the documents, the 5 documents which were made a part of the petition bearing number 110/2023, dated 16/6/2023. The said evidence on affidavit, so filed by the petitioner, if so filed by the petitioner on the basis of the liberty hereby granted, shall be subject to cross-examination by the respondents. Taking into account both the parties are hereby represented, the further proceedings of Miss Revocation case number 1/2020 is hereby, and the stay so granted for stay in respect to Miss Revocation case number 1/2020 is hereby vacated, and the parties are directed to appear before the learned trial court, before the learned district judge Gwalpara on 27/3/2023-24. The registry is directed to forthwith send the records to the learned court below, to the learned court of the district judge Gwalpara, so that the said court is in a position to take up the matter on the date so fixed. This court have also taken note of that on account of the petitioner's not submitting the evidence on affidavit at the proper, submitting the original documents at the proper time, unnecessary time, unnecessary at the proper time, judicial time have been unnecessarily lost, and thereby there has been a delay in the said proceedings. This court, however, is also of the opinion that a reasonable cost is, this court is of the opinion that a reasonable cost is required to be given. This court, apart from that, while adjudicating the said aspect, this court have also taken note of that the petitioner is a widow, and the husband.
I'm first wife. He came as a second wife.
Petitioner is the widow.
Yeah.
I'm not saying you are the first or he is the first. Petitioner is a widow, and her alleged her husband was a grade 4 employee. On the other hand, the respondent herein also is a widow.
Yes, first wife. an objection.
Widow. So, taking into account, this court imposes a cost of rupees 5,000 to be deposited by the petitioner before the learned district judge, Walpara, on the date of submission of the additional affidavit of evidence, which is required to be filed on the next date so fixed, that is on 27/3/2024. With the above observation, the direction.
Deeply obliged.
Mr. Counsel, next time, don't make misleading stuff.
My lord, actually, I'm sorry, my lord, this fact was not communicated to, I am on, from the
You should
record, I
know.
was submitting.
This matter has come up many times.
Yes, sir.
Then you should be aware when the records are there.
I'm sorry, but.
M11.
Yes.
My lord,
What is this FAO against? What is the order?
My lord, impugn order is page 65, my lord.
Page
65 and except 12, my lord. What happened, my lord? In this case, the petitioner has plaintiff filed title suit matrimonial, my lord, number 142 of 15, my lord, and subsequently the suit in the suit the petitioner filed affidavit, my lord, SPW1, my lord, and it comes. Order for dismissal.
Yes, you did not file the application.
My lord, on
Why
the
didn't you file the application?
my lord, I did not file on 31st May 2023, my lord, the original should appear for hearing on a petition filed by the respondent, my present respondent, for additional written statement. On the very date, and that was fixed for hearing on hearing. I could not appear, my lord, due to the mistake of my counsel on the part of the counsel.
That I understand.
Yes.
But thereafter,
My lord,
you
the
filed an
suit was
application
dismissed.
for restoration.
Yes, but I have not.
When
filed
you
my-
filed the application, wasn't it required to be filed by you?
Yes, ma'am.
Why did the lawyer file?
Learned advocate for the petitioner filed the application, ma'am.
Did he say that it was his mistake?
Yes, ma'am.
Let's see that.
Learned counsel for
No,
the.
let us see that application.
Yes, my lord. The application is page, my lord, 56, my lord.
Hmm?
56, my lord. Paragraph
Understood. The
13, my lord.
56 petition which you have enclosed.
56, my lord. An application under order 9 rule 4, my lord. During the proceeding of the instant case on demand, the opposite party filed an application under so rejection so. The petitioner on demand petition was pending for some time and hearing in the matter could not be completed, but however on demand the afternoon last the constituent, although the counsel for the petitioner collected the next date of the suit on demand, but however inadvertently due to bona fide mistake, the counsel for the petitioner posted the suit on demand instead of so and so. Paragraph 7, 57.
The suit was fixed for what?
Actually,
For hearing the application under order 8 rule 9.
yes, my lord,
And how can the suit be dismissed?
that is the main ground. That should never fix for hearing, but the suit was fixed for hearing on the petition 802, my lord, petition number 802, what was
What was the value of the suit, Mr.
actually suit is for
Huh?
divorce, my lord. It was filed by the present appellant for divorce. In the year 2015, my lord. Only they are living separately. On the ground of separation, my just 1 year is sufficient.
Why have you moved this application under by filing an appeal?
Order 43, my
Why? That order was passed under what provision? Under order 9 rule 4.
actually it requires to be 7, my
Understood.
yes,
But isn't it an order under order 9 rule?
it requires to be 7, my it is wrongly quoted.
Huh?
Wrongly quoted, my
What?
because the case was fixed for hearing.
Understood.
Hearing means that order 9 rule 7 will affect. But it was filed in order 9 rule. Some mistake is there.
No,
on
order
part.
9 rule 7 is different.
Yes.
That is against the defendant. The
Yes.
defendant can file an application for expert. An appeal only lies against an order under order 9 rule 9.
Rule 9. Yes,
Is this an order under order 9 rule 9?
yes, but it was the petition was in the petition. It is put as order 9 rule 4.
Yes, when can you serve it? These are matters to be Thursday disposed of.
Yes.
I think it is like that. The order is palpably wrong.
Yes. Yes.
See again the order.
The learned court below, my lord, it requires to be considered the petition number 802 of 2020, my lord, on the credit, but not push of the whole suit.
Court could have at best allowed the order 7, order 9 rule 9,
Yes, ma'am.
order 8 rule 9.
Yes.
Mr. Das, you can expedite the service.
Yes.
By 20th of March, can I fix it?
Yes.
You can expedite.
Yes.
And then if it is before me, I'll set aside this order.
Yes.
Unnecessary this type of matter. Give you the dusty service. You take dusty service.
My lord, if
Otherwise, the service can't be met out.
husband was with my lord.
Huh?
It is husband and dispute, my lord.
Understood?
Yes,
No,
sir.
no,
But-
she does not need to go.
But I reset Guwahati, my lord. Matter is from Tinsukia, my lord.
Understood? You can ask somebody to deliver from your clerk. Your clerk can deliver it. She doesn't need to go. Affidavit can be filed by the clerk. Yes, I have delivered it.
But if my lord allow me, I can take in a speech post service, my
The speed post also not. It won't come so soon.
courier, my lord.
Anyway,
If possible.
okay. The appeal is admitted. Issue notice to the sole respondent. The petitioner is directed to take steps upon the said respondent by way of the registered as well as usual by 6th of March. Further to that, the petitioner is given the liberty to take steps by way of custody rooted to the registry of this court. Taking into account the matter in its entirety, this court does not find it relevant to call for the records. However, the petitioner is directed to produce a certified copy of the application filed under or filed for restoration of the suit, being petition number 1939 of 2023. List আগতে দিছো না কি একটু নোটিস তো দিল না returnable on 23 2023 really
Attempt 12.
yes what is this
In regard to my lord, claiming certain share in the property, joint property, my lord, partition suit has been filed, and my lord, since certain my lord apprehension about alienation, there we have also filed application for seeking injunction. Now, my lord, without considering any material facts, my lord, my ex parte injunction has been rejected. Page 53, my lord.
Page
53.
you are the respondent.
No, I am the plaintiff.
You filed in the petition Iman peruse the year also heard the learned counsel upon careful and you that should not be in just and without hearing. So ex parte not rejected.
My lord, kindly see, not rejected, but question is that, my lord, the position right now is that now they are trying to, my lord, alienate the property. Last, my lord, the month of February, they have already discussed with certain persons to, my lord, alienate the property. That is the one appearance. And the second, lordship, kindly see that this is a state type of order, my lord. So what happened upon careful appraisal of the above observation going through the provision of law? A provision of law, my lord, I don't feel that he has gone through the provision of law, my lord.
He has gone on not that is his way of writing.
Understood. My lord,
Then-
kindly see that provision law said 39(1)(a) that any property in dispute in a suit in a danger of being wasted, damaged, or alienated by any party to the suit or wrongfully sold in the execution. But that word is their alienation. That is my prayer which I have made, my lord, in my injunction.
What
petition.
happened on 27/2?
My lord, 12, next date is 12/3, my lord.
Huh?
Next date is 12/3.
The fixing 12/3. Then
My lord, the next date is 12/3, that will come up. But question is that, my lord, my only at that moment prayer is that, my lord, either status to directive be maintained or, my lord, that they may be restrained from alienation of the property, my lord. Lordship has already decided in my lord, in one of the judgment.
what?
Just one line, my lord, I'd like to. Dalpat Kumar, that I think, my lord.
What does it?
My lord,
What
that,
are you asking for?
Only one line, my lord, which I would like to place that about that sound judicial discussions, my lord. No test has been made, my lord. That is my grievance, my lord. Paragraph
What?
15. Paragraph 15. This is lordship judgment. To exercise sound judicial discretion to find the amount of substantial mischief for him. There is a case of mischief and injury, my lord. The golden principle required little bit of a discussion, my lord. Nothing has been done, my lord. Now they are taking the advantage of the situation already discussed with some local partners for alignment. The defendant once came to know about this fact of, my lord, filing a suit, my lord. They have already last month discussed with local people for alienation of one of the part of property, my lord. That's only the appearance.
Then what is your apprehension? Let us see in the
Last week,
injunction.
my lord, in the month of February, they have already discussed with certain local people for alienation one part of the joint property. Now this is the widow, my lord. How they will run? She will run here and there, my lord, to suppose stop them. Thank you, little protection, my lord. Otherwise, my lord, the property will be in a dangerous state of affairs. It will start there, my lord.
But if they sell it, you get a share of it.
Very difficult that lordship knows the price, what will be indicated and what it would be transacted. And my lord, again, my lord, the situation will be created. Let
Are
them
we
come.
to take judicial notice on that?
My lord, share is a separate thing. Question is that, my lord, lordship know it well. Again, made them party. Again, my lord, creates a very felt it to be challenged. Lots of problems will come.
Mr. Zamari, you know how to stop a sale.
Understood, my lord.
Is it required?
The question is that,
For
my
a
lord,
veteran civil
in
lawyer,
family,
it is
my lord-
required. What is required to be done?
my lord,
If a person is going to sell
my
it,
lord, there is very easy today to bypass all these objections, everything, my lord.
Huh?
Now, as of today, my lord, there is very easy to, my lord, bypass all objections, my lord. Wherever we have put objections about even pendency of those ones, my lord. Lordship, there are lots of instances that has been overcrossed, my lord. So, lordship, what I say, my lord,
Very
it is-
well
it
done.
is- my lord, in affidavit, I have stated the joint property. There is only a doubt to that effect. Now, suppose if, my lord,
how are you saying it to be a joint?
because it has been, my lord, it has been, my lord, came from the, my lord, forefather of the person.
How do I know?
But what statement I have made, my lord?
That those are matters are not before.
Exactly, my lord. That's why,
Then why should I give you an
my lord, thing is that, my lord, kindly see that,
the document which you have filed before the trial court is not before me.
my
Then
lord,
how can I grant you an injunction?
lordship will place the document requirement by affidavit. Yes, my lord, these are very local language, my lord. Much of documents are there. That's why, my lord, I have lordship may call for that, my lord, record of.
But you want that the learned trial court to have the privilege of looking into all these documents. And then also the learned trial court did not feel it necessary to grant any ex parte.
My lord,
Whereas on the other hand, you want this court
lordship,
close
otherwise,
its
I will
eyes
place, my
on
lord.
the
There is no problem.
document
Lordship.
and then to pass
Then lordship, give some time, lordship will place it by affidavit.
the learned counsel. You can please me the other document. Don't require the filing it.
Right.
The bunch of documents which you have relied on to produce.
Right.
When?
But 2 weeks time, my lord, because 2 weeks time, my lord, translation I have to done, my lord. Yeah.
Why do you need the translation? By the time the next date is going to happen on
Then, my
12/3,
lord, lordship may fix it Thursday, my lord.
it is on 12/3.
Yes.
Then
My lord, 12/3, my lord, lordship know it well that how that they come with a, my lord, that taking time again, my lord, objection, then hearing it takes, my lord, to dispose my injunction 1 year. There are 17 parties, man. And they will not come altogether into one instance, man. The problem is that now they're taking the advantage of this situation. Already they have made attempt to alienate the property. That is the only apprehension, man. And that widow lady, my lord, cannot run here and there after them, man.
you can serve them
Can serve, my lord, there is no problem.
before the next date.
Does it possible, my lord, only to maintain status quo, my lord?
Please look into that.
Right.
But you can serve it by Friday, by
Fine.
Monday.
Fine.
Take it up on that.
Monday, my lord, little bit. Friday, my lord, I will serve it to my.
Friday is closed. That is the problem. You want to come on Friday?
Oh, sorry, it's Thursday.
Thursday, not Thursday is too early.
Yes.
You can do it.
Then lordship let it.
Thursday, today is Monday, Tuesday,
Yes.
Wednesday, Thursday.
Fine.
You can do it.
Then lordship may fix it to 45. 45.
14 days becomes useless because you are on, next date is on 12.
12, my lord. 12, nothing will happen. I know that.
Nothing is going to happen.
My lord.
But in the meantime, if the court does not pass an order,
My lord, actually, my lord, from
Mr.
11.
Samaria, what you require is this. Let me make it very clear. You need to first, you should have filed this immediately, which you have not. Number two, you serve a copy out there, then I can fix and pass a status and then direct the court below to keep that status quo order till the disposal of that. Then there is the urgency of both sides.
Right.
Isn't it?
Right.
So, what you need to do is serve it
Right.
and bring it before 12.
My lord,
Then only
lordship
you
may
can
kindly
get
fix
the
it
better.
Thursday, my lord. I will attempt. I will take the attempt. Thursday.
The appeal, the appeal. Issue notice making it returnable on 7. The learned counsel appearing on behalf of the appellant cites extreme urgency for which the notice is made returnable on 7/3/2024. The petitioner is directed to take steps by way of the state rooted to the registry of this court and file an affidavit of service on or before the next. I cannot before. Issue notice making it returnable on 7/3/2024. Petitioner is directed to take steps by way of the state rooted to the registry of this court and file an affidavit of service on or before the next.
13.
Yes.
In this case, by the appeal order, the care of the petitioner for injunction was not taken into consideration.
What is this order? Where is that order?
Yes, Procedural order is at page number 91.
91.
91, Lordship. Order dated 22/2024. Petitioner files the incident which is under such in the petition part herewith the annex documents on the petitioner is documented as period for his declaration right in there. Injunction. No an opportunity to be given. So the immediate urgency on behalf of the petitioner has not been taken into consideration. The basic case. But the fact is that Lordship is the FIR. I've annexed all the documents which are a part of the plaint. And the FIR Lordship, it's at page number 50, page number 60. The threat of disposition on behalf of the defendant.
You want the status quo? Status quo.
Status quo.
Till the next date?
Yes.
Next date is 21/3. 23. You have to get it served.
Yes, yes.
Okay. You do have appeal. Appeal is admitted. Call for a record. The Mr. S.P. Chaudhary, the learned counsel appearing on behalf of the petitioner, appellant cites extreme urgency, taking into account that the petitioner's possession over the suit property is in the verge of being the petitioner is being disturbed. Issue notice making it returnable on 23/2023. Taking into account the petitioner is directed to take steps upon the respondent through by way of the steel routed through the registry of this court and file an affidavit of service on or before the next date. I cannot. This is an application filed under Order 39, Rule 1 and 2. 39?
Yes.
I hope. Under Order 39, Rule 1 and 2, read with Section 151 of the Code of Civil Procedure, seeking the grant of an injunction restraining the opposite parties from encroaching upon the land of the petitioner and dispossessing him from the rightful owners and dispossessing him from the suit land. this court have perused the plaint as well as the injunction application. From a perusal of the plaint, it is the case of a petitioner. The petitioner seeks the declaration of right title and interest on the basis of adverse possession, taking into account that if petitioner is ousted from the possession, it would result in furthermore complications. This court is of the opinion that till the next date, the status quo as regards the which land?
Put A lot.
Huh?
Schedule A.
Status quo as
Schedule
regards
A and B.
the
Both are
which land you are in possession?
Schedule A lot. Is the
How
entire
do you say so?
Lordship, it has been specifically mentioned in the plaint as well as in the injunction petition also.
Where? You are in possession of
Yes,
schedule A or schedule B?
Yes, Lordship. Kindly
Let
see the
us see
plaint.
what is your plaint.
Yes, Lordship. Kindly see the they are made in the plaint.
Who are you?
Lordship, I have this land was sold to me, Lordship. I have annexed the document. That is the page number 35, the sale deed.
Hey, does this thing have anything to do with Nikon? Nikon. This Amar Bolwa
Yes,
has
Lordship.
nothing
Yes,
to
Lordship.
do with Nikon.
Yes, yes.
Huh? Okay, I won't take it. This is the matter before any other. Tomorrow. Yeah.
Tomorrow, Lord. Alright.
Taking it, this court is not actually take up the now, list the matter before any other bench without me. The registry taking into account the urgency shown, list the matter. The registry is directed to list the matter before any other bench.
Alright.
Item 14.
Yes. No IA? I-9 no. Okay, what is this matter?
Lordship, earlier today I had got time for filing an IA week's time
For what?
for an ad interim ex parte injunction in this case
Against whom?
against the respondent because Lordship, there was a miscase which was moved in the lower court and the lower
By
court,
the time you are going to file, this matter would become infructuous.
Lordship, the next day in the lower court is on 16th, so on 11th if we have
What do you want? What injunction you want? What injunction do you want?
Lordship to keep in abeyance.
Construct, erecting,
Yes. To
entering into the scheduled plot of land.
Yes.
Then?
And Lordship, we fear that once the notices are served to the respondent, they might alienate this property.
How?
They must
First, they are not in possession.
they are in possession of the
So they are in first injunction application. If you are saying that they are in possession, that means your injunction application is wrong. You are saying adding time restraining them from entering into the scheduled plot of land.
But
Then
we had had a registered sale deed with them to sell the property. After that, we took possession of the same. But in the time for execution of the sale deed, they refused to proceed with the same, and they have forcefully taken possession of the fruit land.
okay. The learned counsel appearing on behalf of the petitioner seeks for accommodation, taking into account in as much as it is the submission of the learned counsel for the petitioner that without that he has instruction to file an interlocutory application. It's the matter after filing of the interlocutory.
Right.
Oh, I will say.
Lordship, the petitioner had filed an IA, Lordship,
Hmm.
and IA was numbered as IA civil number 615 of 2020.
For
The
what?
same has not for taking stay of the order of the
It's
trial.
the counsel. First, tell me, why should we go into this IA business? Where is the IA?
IA is not along with the record. Lordship.
Okay.
Has not.
First, you satisfy me, you have a case?
Lordship, actually, learned counsel Mr. B.K. Bhattacharya was engaged in this case.
Ah.
After his demise, Lordship, I have newly engaged in this case. In the brief, I could not found any copy of evidence or certificate. I have instructed my client collect
So-
them. So kind of huge time I get it.
So as of now, this IA, will this IA survive? This second appeal will survive, taking into account that the certificate is given by a person who is dead. Now, do we continue with an RSA
Yes.
on the basis of a certificate given by a dead person?
Uh,
I hope you understand.
certificate, Lordship.
You see, RSA is filed on a certificate
Yes,
saying that, look here, I am a lawyer. I say
Yes,
that these are very good grounds.
Yes, Lordship. I have.
Now, this certificate is based upon a particular thing that, yes, we hold that particular lawyer is responsible enough to say. And tomorrow, we hold that the lawyer is not responsible. Can we hold so in respect to a dead person?
Yes,
What to do? What are you going to do?
I may be allowed 5 certificates.
The learned counsel appearing on behalf of the appellant submits that he has been recently engaged. Further to that, he also submits that the instant appeal was based upon a file on the base upon a certificate of Mr. B.K. Bhattacharya of Miss of B.K. Bhattacharya since deceased. And as such, he may be permitted to again peruse the grounds on which the appeal has been filed, and thereupon take a decision in the matter. It's the matter after 4 weeks. It's the matter after 4 weeks.
Hello.
That's 16.
I am defendant. This is judgment of reversal. Judgment of reversal.
Then,
Trial court, my lord, dismissed the suit in a matter, it was decreed.
what are your grounds of
Ground, my lord,
what are your substantial question of law?
yes, this at page, my lord,
Then, presumption under section 90 of the Iman,
10.
by the Iman, in respect of the Iman, is sustainable in view of specific denial by the law of incest, and of the first appeal. No, tell me whether the evidence of the earlier proceedings was brought in.
Not profit.
Then,
But
matter
judgment is there, my lord.
Huh?
Specifically stated in judgment.
No, judgment they would not do.
No, my lord.
Whether that evidence was brought in. If the evidence was not brought in, you should have brought in. Without that evidence being brought in, how do you bring it to be a substantial question of law?
Because, my lord, the earlier court held
Because the judgment is not an evidence.
not evidence, right?
So under such circumstances, isn't it required under section 44 or 45 of the Evidence Act to bring on record that the earlier yeah? Let us see the Evidence Act. Evidence Act. Analysis 33. Evidence given by witness in a judicial proceedings or before any person authorized by law to take it is relevant for the purpose of proving in a subsequent judicial proceeding or in a later proceedings of the same judicial proceeding the truth of the fact which it states when the witness is dead or cannot be found or is left. So this has not been done.
Not done.
So next question comes is how far an evidence of the judgment will become irrelevant. Analysis 40, 41 and 42. The existence of any judgment of degree which shall be by law prevent any court from taking cognizance of a suit or holding a trial is relevant fact when the question is whether such court ought to take cognizance or not. So that is only on that. Analysis 42. 41 has no relevance. 42. Judgment, orders or decrees other than those mentioned in 41 are relevant if they relate to matters of public nature relevant to the inquiry, but the state such judgment orders are not conclusive proof of that which they state. So, how does your question of law survive?
It's just matter we have not paid the procedural point. Only point is presumption under section 90. Right court.
No, understood. But that judgment, therefore, your question of law which has been framed is not properly done. Your thing is that 90 could not have been invoked, taking into account that there was in one judgment, it has been mentioned that he denied.
Lord, that is the finding of the trial court.
Understood,
It is
whatever may be.
Yes.
But as of now, can that be a question of law? Because the question of law has to be then on the basis of whether the presumption under section 90 could have been taken into account without the question of there being a denial.
My lord,
There is no denial on record.
denial in present, my lord, in present, years of the earlier endorsed. We have denied it. We have said that earlier case, there is evidence, my lord. Earlier case, our father denied the allegation, and they did not produce the document, my lord. Although at the relevant time, they are parties in this, my lord.
Understood, but that evidence is not on record.
Not on record. Therefore, not on record. Therefore, the presumption provided in the section 90 was not taken by the trial court on specific ground that there is an earlier denial by on judgment reflect that denial is there, and that document is not produced. The judgment itself says that earlier that deed was not produced before the court. That is why
Mr. Dekka, kindly come again back to the square point that earlier judgment was only there before the court. The earlier judgment was only there before the court.
yes,
That earlier evidence was not there before the court.
evidence was not there.
So under
Yes.
such circumstances, the judgment could have been only to the extent of 42 in terms with section 42, which would require further proof.
Yes, ma'am.
So under such circumstances, that judgment cannot be considered to have any impact on the question of law.
My lord, section 90, may I read? My
90.
90. It is discretion of the court, ma'am.
Yes.
My lord, when any document purporting or proved to be 30 years old is produced from any custody, which is the court in the particular case consider proper, the court may presume that the signature and every other part of such document which purport to be in the handwriting of any particular person in that person's handwriting, and in the case of document executed attested that it was duly executed and attested by the person by whom it purports to be executed and attested. So my lord, it is presumption, that presumption was not taken. Why not taken? It is a revision judgment by the trial court. Why he has not taken judgment presumption of 30 years?
But the 13 the learned trial court made that mistake. How could you have taken into consideration certain evidence which could not have been taken into account? Can you say that to be reasonable?
But there is they have not stated regarding earlier suit, my lord. They have not given any rebuttal against the earlier finding.
Earlier, Mr. Dutta, only so much of the evidence can be taken, which is permissible as per the Evidence Act. Now, if the trial court says that 90 cannot be presumed, taking into account that they, in the earlier set of litigation, that this person concerned strongly said that that he has never sold it in the judgment. Now, could that evidence be the basis for not taking into section 90?
My lord, because subsequently we are carried the same judgment. We are sworn, my we are the son of the donor. Since my lord, the earlier order dated title that is 1996 in 1996. In the all revenue record, everything is there, my lord. We have produced the evidence. The earlier proceeding, his present plaintiff and his father was the party to the treatment. They withheld the document at the relevant time.
Now you have said that a gift deed is bad.
Yes,
Then burden is upon whom?
document at the clear proceeding, they did not produce that document.
No, burden is upon whom? You. You are to show that the gift deed is bad.
Yes, it is. We have it is evidence, made of oral evidence that we are possessing since they are our father, because two brothers made. The plaintiff's father and my father are brothers made. My father, the allegation is that my father made a gift deed in favor of father, brother, daughter-in-law. So, my lord, subsequently he sold land to third person. He instituted a suit, my lord, on the basis of that they leave it. In that suit was dismissed, my lord, on a appeal stage, because they did not produce the document. In that suit, my lord, the father and present plaintiff or parties, they did not produce that document at that relevant time. They are waiting for 30 years. After 30 years, they produce the document. When the donor and donee both died, my lord. If they produce that document in earlier suit,
Earlier suit.
yes, my lord.
Earlier suit we are not concerned.
My lord, they are waiting, my lord.
That is a different thing. That is a very clever thing they have done.
They are
One
working for
should
30
also
years.
think about it. Yes,
Hello.
that can be
Now
one
they-
of the things which can be done.
That is happened, my lord. The brother, one brother, in spite of his children, he did to her daughter-in-law, my lord. And after the death of daughter-in-law and the donor, my lord, they filed it in civil dispute. And my lord, we have not claimed any counter, we have not made any counter claim, but burden was given to us regarding the document of defendant number 3 and 4. We did not produce any, made any counter claim. So there is no burden, my lord. We have produced the certified document.
Who is Pulsa Ali?
Pulsa is the purchaser from the earlier donee, with the mother.
He filed a suit.
He filed a suit from the gift. He purchased the land from the videos. He donated. That suit, my lord, my father and the father of the plaintiff were parties. They did not produce the document at relevant time. That is why that suit was dismissed by the original produce.
Then?
Then, my lord, we are possessing revenue record is continuing in our name, my lord. There is an 145 proceeding also there. Yeah, that was in our favor, my lord. Subsequently, he introduced to was ultimately in appeal dismissed. We are continuing, my lord, by residential houses. No, whole 7 because there are several documents. There is no specification of which ducts or how much land is there.
Mr. Idaka, you don't have a case.
Case is there, my lord.
No.
Case
The
is there
fifth
is
case for dismissal.
I will try to formulate.
These points are not, these are not substantial. Because you can't base your substantial question of law on the basis of certain facts in view of section 42. You have to think about something. I'll give you time for that, a week. Think about it.
Yes.
You don't have a case.
We'll try to formulate things that are
Mr. P.S. Dekar, the learned senior counsel, submits that he would reformulate the substantial questions of law which have been stated out there in the plaint and in the memo of appeal. A week's time.
if they
The instant application under Article 2 to 7 of the Constitution has been filed challenging the order dated 3/6/2016 in title suit number 14 of the 2015, passed by the learned civil judge Golaghat, whereby by the impugned order, the learned trial court rejected the application of the petitioner, who were the defendant numbers 1 and 2, for accepting the written statement which was filed 13 days beyond the permissible limit of 90 days. This court have duly perused the said judgment, the said order dated 3/6/2016, and from the perusal of the same, it reveals that it was on account of the mistake committed by the learned counsel for which the written statement was not filed within the due date. Considering the judgment of the Supreme Court in the case of Kailash versus Nagpur reported in so and so, which has held that the filing of the written statement to be directory. However, the requirement of showing good reasons for not doing so. This court is of the opinion that in the facts of the instant case, the learned court ought to have permitted the filing of the written, the accepting of the written statement, more so when the written statement was already filed along with the said application. Taking into account the above, this court interferes with the order dated 3/6/2016, and thereby directing the learned court of the civil judge Golaghat to accept the written statement of the defendant numbers 1 and 2 in title suit number 14/2015. With the above observations and directions, the instant proceedings stands disposed. The parties herein are directed to appear before the learned court below on 2nd of April 2024, so that the learned court below shall proceed with the further disposal of the suit in accordance with law. The interim order passed on 22/7/2016 stands vacated accordingly.
Item 51.
Yes,
Made with the lordship. In this case, lordship, the first appellate court remanded the suit lordship with a direction to send the exhibit A for expert opinion. Accordingly, the exhibit A was sent for expert opinion, fingerprint expert opinion. The fingerprint expert opinion, and we objected to that report. Prayed for further lordship, further report lordship, further exam.
of
As because the fingerprint, as the 6 fingerprints were taken of the plate, those were not compared, only one was compared. So we have filed objection to that report, and the other side also filed their objection. The petition filed by us, that was rejected by the current tribe. I will take your lordship to the first to the appellate court judgment, demanding back of the suit for expert opinion. Page 45, para 11.
it was sent to the trial court.
Yes.
Then what happened?
Then lordship, the director 5 page 48, forwarding of fingerprint expert opinion. With reference to the subject cited above, I am forwarding herewith the fingerprint expert opinion along with all related documents in connection with title number 20. Then Lordship, the opinion was given in page 53. Result of exam. The question document finger impression marked at exhibit A60 to A30. Further marked as Q1 to Q15 are identical with the specimen left thumb impression of Sirajuddin marked as S1 in annexure C. My objection is that if annexure A, B, C, D specimen left thumb impression of Sirajuddin.
I've seen all these things, but see the order.
Yes.
Did you ask for cross-examination of the witness?
We are challenging that report, so we are
So if you
saying
are challenging the
further-
report, how do you challenge the report? Let's
That-
see order. This will come under the
Order
provision of
26.
Order 26 Rule 10A, and Order 26 Rule 10A has to be read in conjunction with Order 26 Rule 10. You have the leave to cross-examine, and thereupon the court will form an opinion as to whether it has been rightly done or not. You have not taken that opportunity.
Computer for scientific investigation.
Before that,
But-
no. Order
Procedure of
26 Rule
commission.
10A says the
But-
procedure in Order 26 Rule 9 and 10 shall be followed.
But-
Now, see Order 26 Rule 10-2.
Commission to make local investigation and then procedure of
10-2.
commissioner and to report and depositions to be evidence in
Then read it.
But-
What is it?
the report of the commissioner and the evidence taken by him, but not the evidence without the report, shall be evidence in the suit and shall form part of the record. But the court, or with the permission of the court, any of the parties to the may examine the commissioner personally in open court, touching any of the matters referred to him or mentioned in his report, or as to his report as to the manner in which he has made the investigation.
Then 10-3.
Commissioner may be examined in person, where the court is for any reason dissatisfied with the proceedings of the commissioner, it may direct such further inquiry to be made.
So when will the court be dissatisfied? When you put the loopholes out there, you have not taken that steps in terms with 10 Order 26 Rule 10-2. You should have asked that let me first cross-examine him. And when you ask him to cross-examine, these are the things on the basis of which you are to file your application. You have not done that.
First, Lordship, we have sent Lordship that some impression 4-5 numbers. Only one was examined, it is reflected in the report itself.
Understood. So then your petition has to be without even a cross-examination of that. Otherwise, this would be always an evidence if you don't put the expert to cross-examination. Then that is why the order seems to be absolutely right. That you should have summoned him.
That was the objection by the other side also, that we have not. asked
Yes,
for
this is it. They are
cross-examination,
rightly done it. And this matter has been unnecessarily pending for all this while.
Then Lordship, give liberty to file an appropriate trial for cross-examination, calling the expert for exam.
Now, the instant petition under Article 2 to 7 of the Constitution has been filed challenging the order dated 18/5/2023, whereby the learned court below, that the learned court of the Munsif number 1, Karimganj, had rejected the petition filed by the plaintiff
Annexure 6, page 88.
Page
88.
to reject the expert report dated 17/3/2020 and further seeking a direction to send the thumb impression of the plaintiff for examination. The learned counsel appearing on behalf of the petitioner submitted that there was a mistake committed by the lawyers conducting the case of not availing the opportunity in terms with Order 26, Rule 10(2), seeking the cross-examination of the witness and thereupon filing an appropriate application if something could be discerned on the basis of the said cross-examination. She therefore submits that she would not like to press the instant writ petition. However, liberty may be given to the petitioner to avail the said opportunity of cross-examination the witness, the expert of the expert witness who had given the opinion. Taking into account the above, this court closes the instant writ petition instant proceedings. However, taking into account that there is a very vital right conferred upon the parties to the suit to examine the commissioner in terms with Section Order 26, Rule 10(2), grants the liberty to the plaintiff oblique the petitioner to file an appropriate application before the court below, before the learned court of the Munsif number 1 within on or before the next date, so that the learned court below can take appropriate decision on the aspect. Accordingly, this court, taking into account that both the parties are duly represented, this court directs both the parties to appear before the trial court again on 27/3/2024. On or before the said date, the plaintiff oblique the petitioner shall file an application, would be at liberty to file an application in terms with Order 26, Rule 10(2) of the code, and if such application is filed, the learned court below shall take appropriate decision in accordance with law without being influenced by the order dated 18/5/2023.
One more objection have taken the other type that the order with signatures were sent in the year 2020, and it is reflected in page 57. Your lordship will find the Tapan Rajbakshi dated 19/12/2019. It was signed by the concerned party.
You can put that in a cross-examination.
For that, lordship, liberty may be granted if we are dissatisfied. We can again challenge this order.
No, you cannot. If you are dissatisfied after the cross-examination, if there is anything happens out there, you can only challenge it under 105. The above observations and directions, the petitions, and so yeah, interim orders which were passed earlier.
Upright.
Highly.
Supplementary item 50.
Yes, what is this?
May I please, your lordship?
Hmm.
Not a mistake, the IA civil 129. Because for the
Good.
for the improvement of party.
Yes, what is this case about? What are you challenging?
I am challenging a
Huh?
impugn order at this, my lord.
Promotional order?
No. Sir, at the stage of DW, my lord, a new document was actually a petition was filed to allow the defendant to exhibit a new document. That was not allowed. Subsequently, a review petition was filed before the trial court. That was also dismissed. Thereafter,
What document?
a document, my lord, that is exhibit. Document, my lord, is registered till it, my lord, dated 7 November 1960, my lord. Dated 7 November 1960. That is not before your lordship. I have
Understood. 7 November 1960 is a document which you want to exhibit.
Yes.
Very well. Now, it must have been somewhere in the pleadings.
No, my lord, that is there, my lord.
Then, how
My
can
lord,
you allow?
it comes to the knowledge of the petitioner, my lord. That I have.
So, did
explained
you
in my
file an
petition, my lord.
application for amendment of your written statement?
No.
Then, rightly done. That ends there. That is the main question. Can you give evidence the horse you are pleading?
My lord, it is at the stage of DW, my lord.
It
They can-
is
they
at
can-
that stage of DW. It may be even at the stage of appeal also.
So far,
You want to adduce a document which is not a part of the pleadings, you cannot. You have to mention it, that this is the document. This document, there is a sale deed or something to that effect. Can there be any evidence beyond the pleadings?
my lord, this is the petitioner before your lordship. You want to adduce this document only to support another document, my lord, which is already exhibited, and that is in the pleading.
You
Only
want
to
to support any other document?
Yes, sir. That's correct.
You are the defendant.
I am the defendant.
So what is required to be done?
My lord, the contention of the document is that.
So that document is not relevant because it is not a part of your pleading.
But my lord, for the proper adjudication of the matter.
Why do we need proper adjudication? The proper adjudication has to be balanced on the evidence standard.
Yes, my lord.
You did not. Unless there is a pleading, there cannot be any evidence. Can you go beyond the pleadings?
But my lord, that is
The only question which we will ask, Mr. Iqbal will ask at the time of cross-examination is this a part of your pleadings? And the moment you answer no, matter finished, all these proceedings becomes useless.
this document is only to support another document, my lord.
Don't support them.
And it comes to the knowledge of the petitioner, my lord, subsequently, my lord. As when it comes to the knowledge of the petitioner, then only, my lord, it has to file that.
Where is the impugn order? Let me dismiss it right now.
Page 81.
Page 80.
My lord,
Yes.
regarding,
Yes,
my lord,
Mr. Iqbal,
implement
what
of
do you have to
parties,
say?
a petition also pending, my
Huh?
implement of parties. Because the respondent number 2, 3, and 5 expired. On the last occasion also, the
In absence of them also, my lord, it can be disposed of.
respondent also, my lord,
Don't worry about those people. We are not concerned with them.
they have filed the matter.
If I dismiss it, no prejudice is caused to them. Isn't it?
Otherwise, my lord, the respondent number 1 also, if expired on the last date, as cited by the respondent side, my lord. So until and unless
Not don't worry with all these things. Simple question is whether it is a part of a pleading. No.
I'm going to the petition.
Why do you need so much of deliberation here and there?
In fact, the document you want to support, my lord, that is also not a part of the pleading.
Then
And that too in a review application.
let me write down.
All of them, appropriate petition may be filed before the
Huh?
trial court. Then appropriate petition may be filed.
This is a review application. Page 81.
Page 81 review, order passed in review.
Where's the original order? Huh? Original order is here. 18/1/2020.
At page 69, my lord.
Huh?
Page 69.
Page 59 is the order.
69. 69.
69 is the order.
18/1/2020.
Today is the date fixed for a manner as paid, he may be permitted to submit a certified copy of the sale deed dated when according defendant can submit and maintain it because there's no reference to the any evidence. The defendant has also sought permission to submit the application of money by not. The instant the application under Article 227 of the Constitution has been filed challenging the order dated 18/1/2020 as well as 7/3/2022 passed in title suit number 22/2014. From a perusal of the proceedings before this court, it transpires that the respondents herein, as plaintiffs, had instituted the suit being title suit number 22/2014. Pursuant to the filing of the said suit, the petitioners herein, who were the defendants, filed a joint written statement. The evidence of the plaintiff was duly complete, and thereupon the defendants adduced evidence. After completion,
They have filed their evidence.
filed the evidence on affidavit. At the time of filing the evidence on affidavit, the defendant sought for leave to bring on record a sale deed bearing deed number 6471/1960 dated 7/11/1960. In terms with Order 8, Rule 1A3. The said leave was rejected by order dated 18/1/2020. Subsequent thereto, a review application was filed seeking review of the order dated 18/1/2020. This review application was rejected by the order dated 7/3/2022. And under such circumstances, the petitioner has therefore approached this court under Article 227 of the Constitution. While hearing the matter, this court had put a specific query upon the learned counsel appearing on behalf of the petitioner as to whether there is any mention whatsoever in respect to the deed of sale bearing deed number 6471 dated 6471/1960 dated 7/11/1960 in the pleadings of the defendants. The learned counsel for the petitioner with all fairness submitted that there is no mention in the written statement about the said document. Taking into account the above, it is the opinion of this court that the orders dated 18/1/2020 as well as the order dated 7/3/2022 requires no interference, more so in the proceedings under Article 227 of the Constitution. Accordingly, the instant proceedings stands dismissed. Dismissal, this court, before parting with the record, this court, however, observed that the dismissal of the instant proceedings shall not preclude the petitioners to avail such proceedings, if so otherwise advised, if so otherwise permissible of the.
Deeply open. My lord, one more, my lord.
I gave you more.
Dividing may be given.
That is what I gave you.
Oblige.
That is what I told you. Or you want this court to be your advisor? Keep this court as an advisor. I've given you clearly
Oblige, Lord.
what to do.
Item 17.
Yes,
Lordship, this,
somebody died,
yes, Lordship, this
then
appellant number 1, I filed appropriate application.
when?
On 9/5/2020. 9/5/2020.
You filed an application.
No, I have not filed any application.
Then?
Very recently, I have to come to know about.
It was categorically mentioned on when BJP Learning Council appearance said that she has been informed that the appellant had expired and therefore she prayed for some time to file application. Then on 17/11, we are 90 days is all
Because the
gone.
communication was given, but they not
Yeah.
the
You have till now not filed. Who died?
the appellant number 1, Lord.
Only appellant number 1.
Only appellant number 1.
Who is appellant number 2?
Appellant number 2 is the wife.
Oh, then no problem.
Son and daughter is there. Son and daughter.
That is there, but it's not required. The appellant number 1 is duly represented
Yes,
here
the other
by
one
number
is
2. So it does not abate.
Does not have it.
Now what else is required?
That Lordship is the matter of fact.
Ah.
Meantime, but then I-
The Learning Council, Mr. So-and-so, SP Chaudhary, the Learning Council appearing on behalf of the petition appellant submit that though the appellant number 1 had expired, but the estate of the appellant number 1 is duly being represented by the appellant number 2, taking into account the above, this court is of the opinion that the instant appeal can proceed, therefore, without the substitution of the appellant number 1, who accordingly lists the appeal for hearing in its usual course.
2010. Have it.
Huh?
Any date.
Usual course also it will come.
It will come in the part 2. Hearing is-
Nowadays we don't do part 2. Part 2, there is have you seen the list? We don't say that hearing will be taken. All the part 2 matters are then taken up. I brought it. So tomorrow you will
18.
find a lot of part 2 matters are there in part. Yeah. 18. What is this? Why the matter has come up? No reminder has been issued, but no records of so-and-so have been received by the section here. Right? The registry is directed to forthwith take appropriate steps for requisitioning of the records of title suit number 72/99 pending before 99. This court further finds it relevant to observe that the instant proceeding is of the year 2010 and the delay in obtaining the records is delaying the disposal of the instant proceedings. The registry shall therefore forthwith take appropriate steps and upon obtaining the records, list the matter for hearing in its usual course.
What if the one difficulty is there?
Yes,
Here in this case,
Yes, that I told my lord, this case has been appealed, told that there is a problem in this case. Because before filing the appeal, response number 1, which arranged the response
against the
number 1,
dead person, the appeal was prepared.
it was expired. So my lord, there was no brief with me, my lord, honest opinion, my lord, I made several attempts to correct the brief. It's like not able to take
At
the
the
brief, my
trial
lord.
stage, Lordship,
If
this
the brief
substitution
allow me
was
to
done.
some time, my lord, then I take necessary steps, my lord. Sir, appellant number 2, my lord, Pulin Roy, he's also expired. Only few days back, I received information, the client just somehow collected my number and informed me that my lord, Pulin Roy is also expired.
So the-
Yes, Mr. Chaudhary, what are you saying?
Yes, Lordship, this the appeal that has been preferred, this is against the dead person because the Raghunath Gwala, he was duly substituted the trial stage. But in this appeal, when it has been preferred, he has been added as a respondent in the appeal, and accordingly, when the notice was issued, the report came that the person expired. So we filed an objection with regard to that for dismissal of the second appeal as not maintainable in view of the fact.
It will be dismissed then.
Yes, then
Then application is pending with regard to that.
My lord,
Can't keep this matter. pending.
Exactly, and
Nothing
it's
but
pending for a long
all
period
the
of time.
photo, my lord, wrong, my lord, put a photo of that, client may not be stopped.
How do you filed it wrongly? And the response number, all these other things are government or
Exactly, no. The government.
One opportunity may be given, my lord, for
no, there's no opportunity here, business. You file against the dead person, the appeal is useless. Can't help it.
And this application is pending.
You are not careful with that. In the order it has been shown, na?
Yes, yes.
Where is that order?
An application lodged with in the mistake number 2400, they have filed one mistake. It's 2400 2011.
It is also dismissed for default on 20.
And it was 2 occasions
Okay.
it was dismissed for default.
We finish it now.
They are not pursuing this
Enough
matter.
for enough.
And the objection to that, in application praying for dismissal, we have specifically made a mention with regard to the fact that the trial stage, the person expired and accordingly decree was corrected.
Suit was filed by Raghunath Goala,
Raghunath.
and the suit was decreed
Yes. Appeal
during
preferred,
his
appeal
lifetime.
dismissed. Appeal preferred, appeal dismissed. Now the second.
On the death of Raghunath Goala,
Long back, the substitution is taken.
suit is valued at so and so. It is ordered that the suit stands decreed or contested. Plaintiff has a right type that. And against that, appeal was prepared.
Yes.
And appeal was prepared being received by the plaintiff. The second appeal, the instant second appeal has been filed challenging the judgment and decree dated 29/2010 passed by the learned civil judge Hailakande in title appeal number 5/2007, whereby the said appeal was dismissed, thereby confirming the judgment and decree dated 18/12/2006 passed by the Court of the Civil Judge, Junior Division number 2, Hailakande in title suit number 72/1999. It is relevant to take note of that the suit was filed by one Raghunath Goala, who was the plaintiff. The said suit was decreed during the lifetime of Raghunath Goala, the plaintiff, by the judgment and decree dated 18/12/2006. Thereupon, the appellants herein, being aggrieved, have preferred an appeal before the court of the
Civil judge Hailakande.
Civil Judge Hailakande, which was registered and numbered as title appeal number 5/2007. The record further reveals, and more particularly from a decree which have been enclosed to the appel memo, show that during the lifetime of the said Raghunath Goala, during the pendency of the said appeal, Raghunath Goala expired, and thereupon various persons, his legal representatives, were duly substituted. On the basis thereof, pursuant thereto, the suit which was the appeal which was filed was dismissed by the judgment and decree dated 29/2010. The appellant herein thereupon did not file an appeal against the legal representatives of late Raghunath Gwala, but rather continued, but rather filed an appeal in the year 2010 against Raghunath Gwala, a dead person who was long dead at the time of filing of the said appeal. Taking into account that the appeal was not directed against the legal representatives who were already brought on record before the first appellate court, the decree and judgment and decree dated 18/12/2000, the judgment and decree dated
29/2010.
29/2010, passed in title appeal number 5/2007, had attained finality, and the same cannot be now disturbed after a lapse of more than 14 years. Moreover, the appeal having been filed against the dead person, the instant appeal is not maintainable. Consequently, the instant appeal stands dismissed. However, cost.
I don't have any contact with the client for like 14 years. 14 years.
However, in peculiar fact of the case, this court is not inclined to impose
The stay order.
make it.
All right. Nineteen.
Yes,
Order Rosba court order dated 28/4, it came to know that students
yes.
so
What do you want to do?
it
Huh? What?
weeks time may be given by the period.
Ms. So-and-so, the learned counsel appearing on behalf of the petitioner appellant submits that taking into account the office note dated 28/2/2024, the order of the Lozima Court dated 28/2/2024, 2 weeks time may be granted for taking effective steps. List the matter 2 weeks.
Ready?
Yes,
Yeah, yeah. The last paper for
no steps have been received by the section till date. Matter has been laid before this court for further order. Why?
the address has been changed.
Huh?
The address of the respondent has changed. So therefore, we have before that we will find the proper address.
This is an arbitration petition for what? Section 11.
Section 11.
Section 11 petition, should it continue like this? Huh? People are dying. But your proceedings under Section 11 is not started yet. Does anything remain in this matter? Huh? This is a case for dismissal right away. Let us see what is the ground on which you are asking. Where is the arbitration clause?
Okay.
Where is the arbitration clause?
Page 20.
Page
Page 20 of the meeting. For 15.
is 20. This is the lease deed. Huh?
Yes.
Lease deed is made on first of remand between
After,
Jiban Borua and Urban Home, Rajiv Thakur. The letter is the owner of
it was earlier listed and the past this
letter has continued. Who is the lessee? Lessee is the second party.
Yes.
Now you have not been able to serve upon the lessee. Why? What?
you have taken step for
What is it? Show me the notice. Where is your notice for appointment of an arbitrator? Where is your notice?
this is the case fact.
What is the address of the respondent number one?
Number one.
And respondent number one is not a party? Is he a party to the instant proceeding? Huh? How are you making the respondent number one a party? See the lease deed. Where is respondent number one? Only one person is there, Rajiv Thakur. Then why are you making all other people a party? The lease of the deed of agreement is between whom? Urban Home and Pavitra Jiban Borua. Then why are you making two and three, one and two a party? Huh? Understood. That is Urban Home. Urban Home is not a party to the instant proceeding.
Proceed. It was earlier proceed after that another date on the 1st October 2010.
Where is that?
It is in the lordship case 10. Lord. Next.
Now, what does the recent Supreme Court judgment say? A document which is not stamped. What does it say? In an arbitration contract, in an unstamped document, what is the effect? What does the Supreme Court? Yes, Mr. Dekar. What does the Supreme Court say recently that the Constitution bench judgment?
Now it will survive on just that the agreement would be valid so for
But can be then action
impounded,
can be taken under 35.
impounded and then
Impounded here. Yes, we
in the
impounded
course
here.
of section 11.
First, if you are ready to pay. Once, therefore, first I have to take an action under 35.
35.
Then only I can issue notice. Tell me. This is the contract for how many years? This lease agreement is there for what is the period of lease? For a period of 6 years.
6 years.
So, first, impound. Will impound it. Then only you have to be ready to pay. Do you want this to be impounded or not? Because the amount which you have to pay now for this lease deed will be much high.
Lease again arbitration.
Huh?
Perhaps we not apply of lease.
What?
No, I think Vidya truly has said if it's a lease under
No, this is as regards the amount, not for terminate any. Because that's for but whatever may be, this is a lease deed for a period of 6 years. And after completion of 9 months, for a period of 6 years from such date, and after completing 9 months in 20, the rent will be increased. So this is an unregistered document. If it is an unregistered document, can this court take into account? The arbitration. Non-stamp is another thing. That is on the question, but can this document at all be taken into account? If it is an unregistered document.
I'll have to check up, but I believe NN Global initially said regarding stamping.
No, recently
again that
Constitution bench say it is a
stamping
question of
good.
revenue.
No.
So the lease does not, arbitration agreement still continues.
Sorry.
But the question is, arbitration agreement will be continued only if it is impounded,
And deficit stamp.
and then they have to pay that.
Yeah.
And if they don't pay that amount, then this court can't proceed with the proceeding.
Correct.
Now, first, therefore, he has to ask this court for impounding.
Impounded.
Without asking this court for impounding, how can they issue notice in view of the recent judgment? We'll have it out tomorrow, but day after. Whether you want to get it impounded or not. If you want to get it impounded, then the question will arise. Otherwise, this agreement cannot be done. And secondly, another aspect arises. Can this court arbitrator can take judicial notice of this document? if it is not registered, an unregistered deed for 6 years?
under 49.
That is only a question of
Stamp.
But can this document be taken? This agreement, yes, an agreement, arbitration agreement will be divorced the main agreement. There is no quarrel with that. But the question is, if the original, because in Chanmai Tea Company and all,
Yes, sir.
the question is, if the original document requires it, it requires. But I think this constitution being only dealt with the question of stamp.
Stamping.
But what about the, if a document which is required to be registered is not registered?
Well, I think they said sans the main agreement, the arbitration agreement will survive despite non-registration. But for appointment, I think they, well, of course, the arbitrator takes it as evidence or not for the arbitrator.
But can this court look into it? Because this court is going to India, the judgment of the SDP court will be exercising a judicial power.
Regarding valid.
Now, if a judicial power can it be exercised on receipt of a document which is not registered, which is compulsorily registered? We'll have it on here. The learned counsel appearing on behalf of the petitioner shall take instructions as to whether the petitioner would take steps for impounding of the deed of lease dated 1/10/2010 and thereupon, and on the basis thereof, for making payment of the requisite stamp. This is the matter again on Wednesday.
F21.
Yes, what is this?
My lord, the respondent claimant have filed a cross objection together with an underwritten application.
What is this petition? Take it by ISI.
3641 is the IA for delay, my lord. Preparing the cross objection. We have filed our objection, my lord, but
What?
Insurance company prepared the appeal notice.
You have filed counter cross objection.
yes,
We have filed before that notice, there are IA notice.
What
The
I?
IA for releasing the deposited amount.
No, which are the IAs before this court today? Objection to prayer for withdrawal of 50%. This is the objection.
Objection they have filed. We have filed for releasing of the deposited amount.
Wait, what is your IA number?
IA number is P868 2019 Lord.
PH 68 of 2019.
Yes.
And what is IA 4010?
4010, actually this was objection they have filed. It is wrongly number is 4101. It is reflected in the order.
No.
Lord.
So you want to withdraw that?
Withdraw the amount. Lord.
Withdraw how much? 50%.
50% they have deposited. Lord.
Very well. And they have filed an objection. Why?
Objection as because Lordship as per their
Objection is filed under in terms of 4101.
Right.
That is also an IA.
that
can be
has been
registered as I.
that has been reflected in the order sheet that is wrongly numbered as I. Lord.
Fantastic. Then what is
Lordship,
3641?
3641 condemnation or we have filed a cross objection, Lord.
126 days.
Lord.
And then
In this case, in 3868, in there they have submitted the objection as because Lordship in paragraph number 4, they have stated that since the liability to pay compensation is on the owner, as such, it is prayed that the application of the opposite for withdrawal may not be considered at this stage, and permission to withdraw the amount may only
that we are considering, madam.
Lordship.
We will
The,
consider.
the
First,
driver
let me first take into account one by one.
Lordship.
There is an objection for the delay of 126 days.
Lordship.
What is the objection?
Objection regarding, we have filed a cross objection lordship against the appeal lordship. Enhancement of, along with the enhancement of the amount awarded by the trial court.
Why this 126 is delay?
Because lordship, in this case, there, due to COVID, lordship, we could not file lordship.
COVID,
Because it was a 19 matter lordship.
you could very well, huh?
It was a 19, it was
You could
Uh,
very well file during COVID IA
after,
4010 or these
And
are
she's a-
2019.
yes, lordship.
You filed cross objection when?
Oh, 6th of December 2000,
2019.
no, 2022. 3641 2022.
4 August 2022. Is it?
Yes.
And what is 3461? That is the delay.
Delay, Lord.
What have you explained?
41. Delay. Delay for confirmation of
Applicants are 4%.
4%.
Then if they win the case, what will happen? If they win the case, tomorrow, how are you going to return the money? You will spend it,
If they will,
then don't take it.
but Lordship, there is a
Tell me, can you, on the basis of your indemnity, you take the money today. On one hand, you are saying you are very poor. You'll take and spend it. How will you return tomorrow if they win the case? Then
that is true, Lordship, but incident took place of this negligence of this vehicle, Lordship. And that is involved, that vehicle is involved. That is established, Lordship. Only parties that learned trial court what decided in this case. So they have raised that point that driving license was not valid. That is the only matter.
yes, what is your ground?
Number three, driving license was issued to 2 persons, man. And we have 3, my lord, by way of his witness.
Hmm?
We have proved that the driving license, which was purportedly issued to the owner driver, was issued to someone else. Capital on quantum, my lord. Income was not proved, leave was not proved. The dependent mother and father, they were working. The mother and the father both were in a government employment.
Wait. Where is the judgment?
The page starts at page 1. The memo of appeal.
Which the Poppy Patrol?
Popcutter is the wife of the in the payment.
Our father in have to my I have joined it. So have they taken 20,000?
Income.
20. As per you, how much it,
But the income was not too small. Whether he was under employment, that was okay.
if that's in there is no
These were minimum wages have been paid.
Much.
Should be around 7,500.
when did you take it? Since
2015, my lord, 25, 8, 2015.
then
Speak later, 1,500.
Pranay Shetty? 5,000? Pranay Shetty take right. Some case says if there is no person out there, no proof, nothing is proof there, 5,000.
So that is not a thing. But when I said, it says that the profit and the other particular.
Here he says, during the cross-examination of the it appears that it is 18,000 as net salary per month. Paragraph 17.
My lord.
As an employee of the private establishment. So there would be definitely a PF deduction from the gross salary of the. So as an amount of the day is considered the proper as salary. It is that he died at the age of 27. Yeah, the mother and father was working.
Lord, father was a Gaupura, mother was a competent.
That
Then also receiving pension.
At that point of time, she was working. Anyways, that is not going to disturb you. But mother, she was also working. But they are entitled to some compensation. But
No, they are entitled. Now the question would be, how do you divide it?
yes, 1/5 was deducted. Taking mother and father both to be dependent on each other. And the other heads where the amounts are reported, those are also on the higher as per the safety.
And what are you doing?
wife.
You?
Wife. House. And the type of not my husband was
And is there any children?
minor children. At the time of they were 4 years.
Now you want 50%. Let this 50% be put out there in the whichever deposit has been made, put it in the nationalized bank against it. And from there the interest let 5 lakhs be paid to them and remaining because it's a huge amount, 64 lakhs, 50%, 30 lakhs, much to be like, or how much we have deposited. Let 5 lakhs be paid to the mother, the wife, and remaining let it be in the nationalized bank wherein the interest be paid to the to the mother.
In this case, the owner driver is also getting.
But then also, the moment the amount is there,
yes, sir.
let it be there in their name. You can take care of.
Well,
huh? What is the age of the children? No, as of now, how much you have deposited?
Well, 50% you have deposited.
And you must have deposited 50% with interest.
That like the not has.
Huh? Because, madam, we are more concerned about the children. Children shouldn't go away without any money. So let it be, we'll do one thing. 7,50,000 be given to you. And remaining be put out in the fixed deposit by the tribunal. Or by your deposit here.
For the risk of.
By the rate, you can do it in a fixed deposit in the name of the two child. And the interest thereof will be fixed to 6 months interest. Can be put in the 6 months and 6 months. If 6 months interest will go to child, how? To the let it be in her name only. And that the 6 monthly interest will go to her direct.
As your lordship. As your lordship, please.
I think that is a better.
Put it on the name of the because the elder one should be around 19 years now, and the younger child should be around 16, 17 years.
Oh, they're born old. This IA has some useless for filing a certified copy. I think IA could be this is an application filed by the appellant. You filed it. Seeking dispensation of filing. The certified copy of the judgment and report dated 31/5/2000 passed by the member for accident claims tribunal in case the 18th of the taking into account the grounds and reasons shown therein, this court is of the opinion that the said leave may be granted. According, the leave is granted to accept the indemnity. More so, the court also taken that the records of the state could be before the court. Accordingly, the IA stands for 40 IA 4006. This is an application filed by the respondent of the claimant, who are also the respondent by the respondent's claimant, the indemnity claimant, seeking condonation of the state of 126 days in preparing the cross objection to the appeal. Cross objection to cross objection in MSA number 2018. This court have really taken note of the provisions of Order 41 Rule 22, isn't it? Order 41 Rule 22, wherein the discretion has been conferred upon this court for permitting the respondent to prepare a cross objection within such time as needed. So this court have duly taken note of the grounds and reasons stated in the said application and of the opinion that taking into account the aforesaid grounds is of the opinion that the grounds and reasons stated therein in the opinion of this court are sufficient for the purpose of permitting the petition, the cross objection, of objector of the claimant of the applicant herein for to file the cross objection. Accordingly, the IA stands allowed cross objection. Taking into account the above, this court directs the registry to number the cross objection and list the matter before this court for admission. This is an application filed by the court. Filed by the applicant who are the claimant seeking a directive from the court for withdrawal of the amounts which have been deposited by the insurance company pursuant to the order dated 28/7/2018 passed in IAC number 4/2018. It has been stated in the said application that pursuant to the order passed by this court in the said interlocutory application, the insurance company had deposited an amount of 32,04,386 before the registry of this court. The instant application has been filed claiming that the said amount be released to the claimants as they are facing hardship. The said application and interlocutory application has been filed by the insurance company objecting to the release of the said amount on the ground that the said amount, if released, on the ground that the appellant found on the ground that the vehicle in question was not driven by a person who was duly authorized, and as such, the insurance the court below ought not to have settled the insurance company with the state responsible with the state liability. This court have duly taken note of the fact. They have also taken note of that the incident happened sometime in the year 2015. So, no, sorry, man.
25.
Incident happened in the year 2015. Until date, the claimant further to that, the two children of the deceased are also at the growing stage for which certain amount is required, and the delay in disposal of the instant appeal would further hamper the requirement, would hamper their further growth in the educational fronts if the amount which have been paid, which have been deposited, is not released. However, this court also have taken note of that the amount is not required to be released at the court. Consider the above. Direct the register of this court release an amount of rupees 10 lakh to the, who is the mother?
Mother is
To Srimati Pomi Paitya Pator upon proper verification and identification. The remaining amount of rupees 22 lakh, 32 lakh,
22 lakhs.
10 lakh,
Yes.
that remaining 20
The 22 lakhs and odd method.
and remaining amount of rupees 22 lakh
08
22 lakh 04,000 386 be kept in a national, be kept in a fixed deposit of a national with nationalized bank for a period of 5 years, and the interest accrued thereon be at quarterly interest accrued thereon quarterly be paid to the be kept in a fixed deposit of a nationalized bank by the registry in the name of a Pumila Patwa, and the interest accrued thereon in the interval of 6 monthly be released to the bank account of Pumi. I put the recording.
Can there be a security from the
We are already happy.
Okay.
Yeah, I would put it.
No,
Not
they need to,
admitted.
no, it's admitted. My lord, they need to serve as the cross object.
Oh, that I have fixed it.
My lord, the present appellant
That is,
I did up in that we have the objection. But thing is this, my lord, who are the defendant, present appellant, as well as the defendants who are made defendants here, they were original defendants in the title. But here they have been made respondents only to delay the case. It is case of 2007. And both the courts below we have got the decree. Now, by dint of forgery, he did a power of attorney that was declared as null and void after obtaining expert report and evidence. And here, when he filed the case, he made his own party as the respondent, wanted to delay the matter. So, Tortip may kindly take up the matter seriously, how he can assist the honorable court by making his own party as the respondent.
whom they have made.
Kindly see page 2 of their affidavit. Here, my lord, kindly say, I am Abdul Basit. I am the plaintiff. Here, respondent is Asan Pramanik, Azam Pramanik, they are defendant, but in this appeal, they have been made as respondent. His own party. And they were part
But
of
they
the
have made as performer response.
performer respondent, and they were original defendant, and they filed joint written statement together.
If these people have not come, so performer respondent they making they have to.
So, because they filed the written objection, written statement jointly before the court with. That is also in record. So when they were the original respondent and jointly they made this force power of attorney and also made a force held it by dint of that power of attorney. Those both the documents, power of attorney as well as service have been declared null and void by the court spirit. Now, when they filed this case, they have made their own party as a proper respondent, not the proper respondent. Can you see page 8? Now, can you see page 8? Here, Asmat Pramanik, Asan Pramanik, this is the title suit. Here, Asmat, Asan, Azam, Quran Pramanik, all are different. And they file WS together. That may be seen by page 16. Page 16. Can you see they are joint affidavit?
Oh.
big difference because their state was common. Now they have made respondent. Their state is
They are not making it respondent, they are making performer respondent. That is permissible under order 41 rule 4.
When the performance has died, now they want to bring the legal heir. It's a case of 2007. Kindly see, then 2007 means 13 plus 4, 17 years old case. So by making performer original defendant as the performer defendant, now performer defendant, some of
Not
them
performer, they are making performer respondent.
performer respondent. Now they have rights, they are making their own parties as the legal representative. So what they will say, their statement will be the same. What is written in the written statement. So what is the purpose of making them as performer respondent? What is the meaning? And their conduct from the very beginning, there is a force held it. So all conducts are doubtful. All conducts are doubtful. And I think court should not allow such person to take the letter of court in such a manner.
Yes.
I have thought that if treatment will not go in favor of him or his nothing there matter. Only treatment is necessary. That can be done, but it will not give a very or demerit to my lot. Another thing, but the guy
It's up to them. But thing is, this purpose is not fair. When they are originally defendant, the title suit, they filed joint statement together. Now in appeal, they have become performer respondent. That means he is making his own party as the opposite party. Only to delay the matter. Original matter 2000.
I have explained
Ultimate is only a performer respondent. Ultimate. Not both, he has already accepted it. But if you, in view of order 41 rule 4, if you are able to succeed in setting aside in the second appeal, then the entire decree will go against everybody. Is otherwise your party only. So we reject this delay at the end of the need to delay the instant application 599 of 2020. The instant application has been filed for condoning the delay in filing a substitution application in substituting the legal representative of the performer. From a perusal of the office note, it sees that the delay is 590 days. This have also taken note of that the performer respondent number 1 was a co-defendant along with the appellant
In the original text.
along with the appellant in the suit and jointly had filed their written statement. This court have also taken note of the reasons which have been given, which in the opinion of this court does not constitute the sufficient cause within the meaning of Section 5 of the Limitation Act for condoning the delay of 590 days. Accordingly, the interlocutory application being IAC 599 of the 2024 rejected. IA 601 of the 2020 taking it The representative of the performer respondent was not the law by court IS 599/24. The instant application also stands rejected. Then, what are these two others? ISP interim order.
But one case matter, I was the 20 order.
Yes, what is the interim order?
But your dot. Eight type of what happened?
So there is a stay to the execution application.
What happened? And my was admitted. It was they was not part of out of so on the notice was in the meantime what happened my God execution was done under that circumstance came before your master by filing IS between 385 of 2020 and it that so notice was it in the meantime started so attested with this why your doctor
Stay the execution.
order on 3
We make it absolute with the disposal. Taking into account I-885 of the sub. But they take the council and get it up. To the part. That the accompanying appeal has already been submitted. With it framing substantial questions of law. And the state appeal is ready. Record the up.
I have been informed that
Taking into account that the record that this court of Interim Part 2023 in IAC 385 of the 2022 of the day of the execution the title execution of case number 6 of the 2002 pending the court of the Munsif Vilasipara. We remain state till the disposal of the connected the second appeal. Taking into account that part of the need to call he's there. Other the performer, you know how to do it. You ask to some of your juniors.
this was a step to that
The Mahmoud, I have paid free. It would not be proper. Am I not then imposing upon my tenant colleague? I can't keep it, but
2007 matter.
no, under
2007
2007
title yes.
yes, we had all the
2007
check-
title
then-
constitution of the same
liberty, it's application for early. So, yeah, this is
was originally filed, the third club. No. Right. Now that has died. That the content order of the past. That is that page. Of the of 5. Now that at this content order, paragraph 4 of without going merit the text or make it right. Wait.
18.
Annexure 2, Your Honor.
Page.
But this was past 4.5 years ago. But no election had for 3 years, which is why I filed the application. I am a the elections have not been held in terms of the order. Let there be a time frame within which the election. Now, but I was one of the founders. In the suit, I was not. Because I was a member. Now, all the members were not. Yes, I thought I agree. And in fact, orders were out. Because it was knows that structures because of this order. So that is what has happened. Now, what has happened was parties approached the trial court said since the entire matter is resolved, there's no point pursuing the suit, and the suit was closed again. Now, the members didn't know what to do, so therefore one of the founder members pointed out before the court that the elections are yet to be. Now, by this time, there's some difference of opinion, but learned senior counsel gracefully agreed to conduct the elections, notwithstanding that some people had some allegation. Now, that was done. Thereafter, if your lordship has the additional trial today.
Election held.
No, election is yet to be held.
This Gymkhana club is going to take, my lord, in the closer stage. Lordship will find the bar, restaurant, all.
Gymkhana club, the secretary is not there.
But I have been, my lord, I have been entrusted by this honorable court to put the election. Now,
In
what
that
happened?
page 16, your lordship will find that I was the person who had filed the plaint. I was the plaintiff in the trial court challenging the election procedure that was being held while putting the election. Now that continued with regard to that, and thereafter, one of the respondents here was who was the review petitioner out here. Your lordship will find it. Now they have filed an application under Order 7 Rule 11 saying that the matter has become infructuous due to the passage of time. Now, which was rejected by the trial court saying that there is matter still subsists because of the relief that were being claimed by me. Against that, they came before this honorable court, and this Gymkhana today, I'm not sure, your lordship.
Yes.
Yes.
Yes. The committee, which is why the application was filed to the trial court. That since the tenure is already over, the suit has become infructuous. But then before this honorable court in the form of put said that with all entire past now, but these orders are already in place. We have no other option but to implement that order. Now, of all members, everybody is agreeable to an election. What is happening saying here, certain members are able to maintain questions regarding eligibility, some are questions against audit and account. Now, when given the tenor of the order, initial order which was passed for the election, he had under the society's rate. Now, in fact, that now with the we are interested, we find the
So Lordship is very right. Senior counsel is aware of the facts.
Exactly, my lord. Exact. That is precisely the point. In fact, I approached to say that the election should be held. Now, my lord, what is actually preventing the election are two.
I had a meeting.
But we have been repeatedly.
How do you bring out here?
Where do the members go now? So long as
Where
order.
the members go to
Register of in fact, that's such a
Lord, members have no interest. They don't have any interest. They want to close it down.
But then we will do that with everything. Nothing out there. But if it to the audit, act with the if they are not act, then
Everything will fall in. Everything will fall in.
everything will fall in. That is the whole direction.
allow me 5 minutes.
No, not for nobody. Nobody. But for the person. We took on the activity. Instead of the it over. Thereupon, they were not by the reason of the act. But the reason into it.
Correct. Yes.
You have to
There's
take
an
a
amendment.
now, what is the reason of anything that
We are I am obligating them not notify text. CRP already
They have filed a review, Your Lordship.
That is the problem.
My goodness.
What has happened here? CRP order said whole election. Did not specify a time frame. 4.5 years it remained like that.
They come in the, complete themselves in a review application.
How can you dispose of matter also?
They
Where's
are
the
coming in a
review?
review application.
Review, my lord, review is already not fit.
Review not fit.
Then what?
There's the review. Like
The review's maintainability was still in doubt with regard to the questions they have.
review not fit. IO. Then IO. There's a clear. Huh? Where by the review? Where by? The purpose
Appreciate
where
that
by
was another comment.
yes. Who are you? Do it not. We won't excite if the truth is not there. How can an interlocutory when was the
Was based on the basis of the judgment passed by the Honorable Court, Your Lordship.
show me?
That
I told
11/1/21.
how could I?
You to
856. देखो the instant proceed the PRP number the PRP IO 244 of 2019 arises out of a proceeding out on the arises of an order dated 23/5/2019 passed by the learned city judge number 1 Metro at Guwahati type number 357 of 2018. Whereby is that order the learned court below civil judge number 1 Amrut Metro at Guwahati, that is the learned trial court, allows the amendment to the plaint and further rejected the application filed under section 150 for dismissal of pursuant to the said order being passed and the instant proceedings being filed . an order was passed on 27/8/2019, whereby a consensus order was passed to the effect that the election of the Guwahati Tipsala, which is a registered society under the Societies Registration Act 1860, would be held as per the rules of the state society. It is further seen that there are various applications and applications filed thereupon, in spite of the fact that the CRP IO 214/2019 was disposed of by the order dated 27/8/2019. It is also very interesting to take note of that on 11/1/2021, the title suit number 657/2015, which was the basis for which the proceedings was initiated before the court, being CRP IO number 244/2019, was closed by the order dated, was disposed of as infructuous by the order dated 11/1/2021. Therefore, taking into account that the entire edifice of the proceedings, that is title suit number 357/2015, no longer being in existence, the various proceedings filed before this court have become redundant. Considering the above, this clause dismisses all the applications filed before this court as the same have become redundant. Be that as it may, the dismissal of all the proceedings would not preclude the parties before this court to file appropriate applications for violation of the order dated 27/9/2027. 27/8/2019, as well as also taking steps before the registrar affirms or file a fresh suit if otherwise advised.
That committee also goes. So they're operating as a high court appointed committee.
This could further make it that in view of the dismissal of the further make that all further other than the order dated 27/8/2000 had become redundant, and as such any committee constituted thereupon on the basis thereof have not become muted.
Everything is.
Obliged.
5.
Huh?
All the student, right? So we have read the substitution petition which is registered as IS 79.
Yes, yes.
And the file 90 days, so it is accompanied with the stay
I
aside of
was
the
appearing for the DC respondent, let notices go.
It's not that you are appearing. You have the,
Or I don't have, no, Manoj, I don't have the. I'm not appearing for the, I mean, they yet to be submitted notices, no,
you have informed the court about the debt.
no, I had. But
Then
they
how
knew,
does he know?
they knew about it, they filed it. I-
I ordered it at 25/20 was ordered that it will be extended to the next date of 8
There was no exception. Huh? What is this? Why the matter has come up for court orders? Delay has been condoned. So why the matter has come up for orders? Neither ID card, passport, no back. Okay, service not complete. You are going to take press service. Now they are not appearing. What to do? Learning council appearing on behalf of the prisoner submitted to take first step of sole respondent. That leave the matter.
In this case, my lord, I have filed an objection, my lord, with the registered in the condonation petition, my lord. I miss IN number 2121
How much is it
2020.
today? Huh? It is.
My lord.
What's the reason?
My objection is not in the file, my lord. I have filed it today, my lord. Objection I have filed today. Yes, my lord. Copy.
This application at the date of 8 date. 8 date, huh?
My lord, paragraph 6 in my objection.
How much is the delay? $98 days. It's very it- oh, but have also stopped. Application that allow the rate to register. Secondly, as well, it at it, but it, I
No, first the condonation will go. There are condonation petitions.
how many RSs are there? Two RSs.
Two are
Huh? Yes, what is that? What is this IA for? Application for according permission for construction of the laboratory latrine for use of the applicant. And there is a delay. There is a delay. Delay has been condoned.
no, madam. First condonation petition will be taken.
Yes, obviously the delay has to be first condoned.
Yes.
As of now, madam, first the question arises whether your appeal is to be admitted or not. How can the court pass an order before that?
No.
Now, therefore, the question is as regards the delay. Without condoning the delay, can the appeal be? There is a delay for what? No, the appeal has been admitted.
Appeal admitted earlier in between the some of the contest facts and the appellant also. Then there is a delay in substitution of the legal
In both the appeal.
in both the
Then the delay has not been condoned.
not court.
Wait. Order 2224 for air substitution the legal air of the when did the response number 4 die? Is a still
Still,
is a status court.
yes. So how the court will, how the debt status quo order will be issued.
You have to file it.
Yes, I filed
What?
241, I filed objection.
Who is in possession of the land?
I am in possession of, I am in possession of.
There are 3 defendants, and each defendant will construct one house in each state, and they are independent. Defendant number
Of 5 years ago, my lord died and his secretary had substituted the law. That's the problem. I the permission for but this not only matter. So according to their they have decided there that as per their own matter, as per their own technical affidavit, my lord, they have said you would that that people for not that there. Top for that shifted to Siliguri and settled there. And some of the co-porters landing my lord. And if the my lord, the death certificate of my lord, they are not attacking a support. That's the also our substitution. But and they are the Lord would be the now my lord, we have to take participants of the use of let's say my lord. We are undertaking my lord, my lord, we will dismantle that my lord, undertaking my lord. Because here are the first. First, we take concept from Papa. Next, is that it was equal. Now we got other thing or Papa for export video. So we the other my lord page our in presence of it of
Yes.
no, actually false my lord.
Yes. This,
Look at everybody may
this
be
is
bad,
my
my lord.
instruction. They are
Everybody may be
at
bad,
the
my lord.
adjacent land, they are constructing building.
Apart
This
from
is my instruction. No. How I can allow in my land to raise construction? Stay. No.
But they
Yes. No. No. My submission is that they are constructing building and they have already constructed the building. And there is a provision of toilet also.
right.
No, my submission, it will create multiplicity of property. Then again, I have to file the petition for dismantling these toilets that if they reach their own.
which undertaking my lord. Undertaking. And my lord, everything that projects no that apart from this particular thing, my lord. We are very poor, my lord.
That
We are
is not
living
there.
there.
That is not the case.
But it is their own
And what is their urgency? They have filed the petition in the no.
Because they have not died.
No, I have denied that. Yes. It is not a fact. It is not a fact.
No, but
Yes. It is denial, madam.
Well, what is the urgency? They have filed petition in the July. What is the urgency? They have filed the petition in the month of July. Now still it is pending. Oh, it is their urgency.
He has been begging time, filing for filing
No, no.
affidavit. He has been taking the matter.
No, no. Yes.
Without it, it was if the other matters come up.
Hello.
File of
Yes, sir.
file of
Yes.
File. It's a date. Page your application first.
Yes.
They have they don't have a security of
9.21.
Okay. File an application under 34.
I think the application number 34.
Huh?
Yes,
You have filed.
yes, I'm filing a video. That is for your lordship. Against
Where is the 34 application?
the
When did you file the 34?
500 of the
34 is where?
arbitration act.
Lordship, application was filed on 13/10/2023. That is attached with the limitation application.
13,
13/10/2023.
21.
2023.
Where?
Before this court, your lordship.
This is against what order?
Not order, your lordship. They have filed an original side applications, your lordship.
Here.
Yes, your lordship.
What is this? That is what I'm asking you. Next. You know, this section 34 doesn't, we don't have the original jurisdiction. No. The instant application appeal. The instant proceeding, a perusal of the application appeal. The perusal of the proceeding, more particularly, the interlocutory application file, as well as the accompanying arbitration appeal, shows that this is an application under Section 34 of the Arbitration and Conciliation Act 1996 against that shows that the application under Section 34 of the Arbitration and Conciliation Act 1996 against the award dated 9/1/2021 has been filed before this court. This court is not the court within the meaning of Section 2E of the Arbitration and Conciliation Act, and as such, the petitioner is the appellant oblique the petitioner is required to take recourse in a proceeding before the appropriate court, if otherwise permissible under law. Accordingly, this court does not find the instant appeal find that the entire proceedings maintainable before this court, for which all the proceeding stands dismissed on the ground of non-maintainable.
32.
Yes, what is this?
Yeah, please, my lord, item 53 may be also taken together with connected matter.
What is this?
Yeah, no, the condemnation of delay matter.
You file objection?
Yes.
What do you say? The
My lord,
opposing?
delay is not bona fide. It is intentional delay. For instance, my lord, the judgment of the first appellate court was passed on 23/12/2019.
Hmm.
And dismissal order, that is 23/12/2019, the filing that 1,362 days.
23/12/2019.
Yes.
Judgment
And
was
here,
passed.
the appeal has been filed on 22/3/2020. Now, they have taken a plea that there is the Supreme Court's order that from so and so that there was those days were excluded. Now, your lordship is aware, Supreme Court's order says that from 15/3/20 to 28/2/22, that period would be excluded.
That I have categorically mentioned in paragraph 2 of my.
But yes, but before that, my lord, before that, they applied after 81 days of filing of certified copy, 81 days. 81 days after, and thereafter, they obtained the
No,
certificate.
first and foremost, let us ask whether the judgment and decree was passed in your presence.
Yes. Yes.
Judgment is a contest.
Contest.
But there is a bona fide mistake on the part of my lawyer. What happened there? He suit filed and there was a counterclaim.
Hmm?
There was a counterclaim. Counterclaim, decreed, suit dismissed. So as per rule, my lord, 2 appeal ought to have been filed. But because of the bona fide mistake on the part of my counsel, my lord, only 1 appeal.
This one. There is already an appeal admitted.
No. Appellate court.
Ah.
Trial court has, my lord, it was a pure civil judge. Only appeal, 1 appeal. Subsequently, my counsel has discovered the mistake that it was a bona fide mistake. 2 appeal ought to have been filed against 2 findings. So subsequent appeal filed. In the meantime, when there was a delay. There was some delay. The appeal was filed with the continuation of delay application. So during pendency of the consideration of the delay petition, the first appeal which was filed against the dismissal of the suit, that was dismissed. Then again, second mistake, my lord, that is through state of affair I have to admit. The second mistake committed that we are on the impression that since the second appeal is pending, that we will file, that will cover our case. But subsequently, that the second application against decree of the counterclaim, that was dismissed on the ground of delay. So there is a, my lord, in fact, the next part after during the 81-day last part delay, my lord, after copy, it was the fact that my counsel who was conducting, he expired. And because of the sudden expiry of the counsel, my lord, we could not obtain the records, etc., my lord, in time. So I have, my lord, categorically stated, my lord, in paragraph 3, 4, and 5 of my application. So neither the appeal, my lord, the first appeal that was filed against this dismissal of suit, it was, my lord, dismissed on the ground of non-maintainability. So, my lord, the case was not hard on merit at all.
That is perhaps my learned friend is not saying correctly, because case was heard at length. Kindly see the order of the first appellate court, the title appeal 42/2017. So it was heard in presence of both the parties on merit, after framing all the issues. And secondly, my lord, the death of the lawyer, it is completely unacceptable because their house is 4 or 5 kilometers away from the house of the lawyer. And these are litigious people. Since many, many years they are fighting. So every day almost they go to Borpeta and their house is near Borpeta and the lawyer resides at Borpeta. So it is not at all believable that 82 days they were unaware about the death of the case. And second thing, my lord, the grounds which are taken absolutely not acceptable. Normally we do not object in condemnation matter, but here intentionally they have delayed. And blame has been given upon the lawyer.
Now, what has happened to the accompanying another IA? There's another matter.
2 appeal, both are dismissed. There were 37, item 32
This is what I think.
is IN number 3207.
32. And the other appeal is
And
main petition.
That is item number 53 and
53 is how
329.
much delay?
IA
53 is how much delay?
53 delays 375 days.
Why?
This is the subsequent appeal which is dismissed on the ground of
No, the 53 is 584 days.
item
53 is 584 days.
3207, my lord, IA. That is 584 days. Yes. Item 32 is IA number 3207. Huh? Sorry.
One is 426, other is 584 days.
584 delay in IA number 3207 and 375 delay in IA number 3209.
But they have said this, but actually that is not correct, my lord. Because Supreme Court has only excluded
And
the period
Patterson, my lord, between Patterson son.
15/3/20 to 28 to 22. And they filed the appeal on 16/10/23. So 28 to 2/22, it is almost, my lord, 1 year. 1 year. And another thing, my lord, they filed the petition after 81 days. For certified copy in IS civil number 3207. So after 81 days petition was filed. So what is the bona fide? And in concurrent finding in our favor, my lord. So I think, my lord, this IAS, the condition of delay should be dismissed, my lord.
This is, my lord, my humble submission would not concurrent finding because the appeal was dismissed, which was preferred against dismissal of suit on the ground of non-maintainability. The landed appellate court had that if the value of the suit is less than 1000, it is appeal is maintainable as per law is purely on the question of law. But here the case is on the question of law and fact both, so it is dismissed. And second one is dismissed on the ground of it. So there is no concurrent finding.
It is item 32 and 53. Huh?
Fine.
And 53. It's the matter again. Wednesday at 2 p.m.
I'm on.
Not satisfied, Mr. Kapoor.
Yes, I have brought certain authority. All right.
33.
Yes, there's some mistake.
Whatever this I have for taking the judgment.
Oh, that one.
That one.
You made the mistake. Not
I-
my mistake.
Lordship, I have forgotten them.
Then what to do? You want some other officer.
Lordship. It is executive engineer, respond number 5, executive engineer and respond commissioner, special secretary.
Where is the other side? It's a big problem. Oh, no one is there for the government. It's PWD, na?
W.
PWD. That is the matter again on Wednesday at 2 p.m. Now, taking into account the counsel for the PWD rejection, it's the matter on Wednesday. You ask the PWD counsel to be present.
I do.
I got the copy of the application today only, Lordship. 2 weeks time may be granted for taking instruction.
What is IA?
IA.
IA is what?
CRP
Implement.
for implement of respondent number 2 and 3. They are the president and secretary of Anjuman and Khatam Walk of Society. It says CRP, so I have filed my implement.
What happened earlier?
Earlier it was a review petition, thereafter they prayed for conversion. Earlier this was a read petition first. Thereafter they prayed for conversion, then it was converted to civil petition.
Now what do you want?
Implement of the president and newly engaged secretary.
Plead as respondent number 20. It can be pleaded as respondent number 25. Do you think? Who are the applicants? You. You are paying for the applicants
Yes,
because you are 2 and 3. Earlier, who were there? 2 and 3.
2 and 3 Ismail Hussain and Mokidul Islam.
No, earlier 2 and 3 was
Ismail Hussain and Mokidul Islam. Page 2, your lordship.
2 and 3.
Yes.
And you are paying for 2 and 3 earlier.
No,
No,
Lordship,
Lordship,
I'm
I
for
am
the
a peer.
petitioner.
He is the petitioner, lordship.
And who was paying for 2 and 3 earlier?
I am preparing.
Earlier.
Yes.
So what is your problem?
Let me verify, Lordship, because Mutawal, the question involved is that because in the plaint, main thing is that there is no authority or no this thing.
Now, this is the proceedings under what?
Walk off.
Walk of it.
So now they say they
Yes, Lordship, that is fine, but today only I got. I want to verify whether it is correct or not, because
Lordship, may I point out one thing? While it was a writ petition, when the writ petition was pending, lordship, then also I have informed the court that respondent number 2 and 3 reconstituted, lordship. New persons came. Then.
no, you must be having a resolution.
Lordship. And then
Produce the resolution. Matter in, let the
Then
matter be
also-
listed on Wednesday, on which date Mrs. R. Chaudhary shall produce the resolution. Resolution,
I have filed.
not necessary. Produce the resolution on the basis of which the applicants came to be the Mutuali and
The president and secretary.
Mutuali, no,
Yes.
the president and secretary of the
Anjuman and Khatam Islam Walk of Society
concerned Wakaf. Produce
Of
that
the-
matter to
on Wednesday.
36.
Hmm.
This, we have filed our objections today, madam.
What is that?
IA 307
IFL what?
3077 we have filed under order 39 rule 1 and 2 matter for grant of injunction matter that was granted.
2A.
2A is filed for violation matter that is IA 38 of 2023.
Who
And
wants a mandatory injunction? You.
mandatory-
Why?
but matter because in the pendency of the matter injunction application matter and the appeal, they have put a team share in between the tenanted premises.
You have filed objection.
I filed my application.
They will not come on record.
Today,
No,
they have
today morning we have filed.
Okay. Leave the matter on Monday. Give a date. on
Can
11.
it be on Friday, madam, next Monday?
Huh?
Next Friday, madam.
This coming Friday.
Yes, no,
15th.
madam, the 15th.
List the as agreed to the land council for the party, matter stands adjourned to be listed on 15th of March 2024. So in the meantime, the registry shall bring on record the objections to file by the respondents.
applied.
Madam, obliged.
37.
Yes,
In this case, objection they filed today with regard to the stay petition. Filed by the
they
petition.
filed objection.
They filed the objection with regard to.
They'll not come on
It is
record.
not. Can it be taken on Monday? Monday.
List the matter on.
Tuesday.
Huh?
On a seniorism is difficult on Monday.
Tuesday, your lordship. Tuesday.
Leave the matter on 13th of March. In the meantime, the objections so filed to the interlocutory application by the respondent will be brought on record.
Much obliged.
38.
Yes, what is this?
My lord, in this matter, there is a small clarification, my lord, if we have sought for.
Hmm.
My lord, in paragraph 23.
Hmm.
My lord, from the bottom, my lord, the last 3 lines, if I may read.
Hmm.
My lord, this court further directs that during this period, from 34/23 till date, the petitioner would be entitled, my lord. Here, my lord, would
Any of the benefits.
any benefits,
But the
shall be for the said period,
But the state period
shall be
would not be.
would not be, my lord.
Okay. The instant application has been filed by the applicant who were the respondents. You were the respondents, no?
My lord.
Respondents in in WPC number 2626/2021 seeking clarification to the order to the judgment and order dated 17/8/2023, more particularly to paragraph number 23. This court, having perused the said order and said judgment, and more particularly paragraph number 23, is of the opinion that there has been an inadvertent error in the omission of a word not. In the penultimate sentence of paragraph 23. Therefore, the sentence, inverted comma, this court further directs that during this period from 34/2003 till date, comma, the petitioner would be entitled to any of the benefits such as salary, promotion, etc. But the said period till date shall be taken into consideration for computing the pensionary benefits of the petitioner, inverted comma close, should be read as this court further directs that during this period from 34/2003 till date, comma, the petitioner would not be entitled to any of the salary benefits such as salary, promotion, etc. But the said period till date shall be taken into consideration for computing the pensionary benefits of the petitioner. Full stop. In not to, into these two columns, that will be bold. Full stop. The instant order shall be a part of the judgment and order dated 17/8/2023 passed in WPC number 2626/2011. Above the instant applications, then
Much of it.
8 page rule
Lordship.
in the
39.
As per appeals made dated 28/24, the matter should be listed before the Wazima court. And there is a defect in the IA also. There is defect in the IA. To listed before the Wazima court.
you want it before the lodgement court.
Yes.
Why?
Because there is the office not listed before IA.
Then there is a delay of 496 days.
What has happened in the Parliament revision petition, there is delay of 62 days. In the meantime, the resolution has expired. We came to know later on, I have studied in paragraph number 2 and 3 of the IA.
And that was long time back. It has not been listed with the lodgement court. Yes, it has been listed.
Listed.
Service report has been received back and regard the service upon so had expired, and in that regard has said he has no son by the name of Rohit Chetty. In view of that, the petitioner directed to the instruction as regards the response number 3A is the legal rare of the response number 3.
There is a finding of this out of trial court, page number 65. Page number 65, they're finding that
Chalo.
the son.
We'll have it on some other day. With the matter again on 20/6/2024.
There is a defect in the this I don't know why. I have not inserted the number of days. The substitution I have inserted but in the Batman, I have
None. Hmm.
I have for delay of 159 days. I think that
LA appeal against
against my lord, the deputy commissioner, deputy collector, and hearing party size.
issue notice. Who
Your-
appears
your
for the
lordship,
state? You
your-
are appearing?
Yes, I am appearing, your lordship. The order has been dismissed on 12/6/2023, and he has applied for certified copy on 9/1/24, your lordship. So after 6 months, your lordship.
12/6, judgment and order dated on Iman.
Paragraph number 7 of IAB, your lordship. There it is mentioned.
Okay, you want to file objection? Okay. Will issue notice?
Yes, sir.
Issue notice, making it returnable by 27th of March 2023. Ms. Swenso appears on behalf of the respondent number
1 and 2.
1 and 2 and accepts notice. First of the petitioner is directed to serve extra copies of the application so that she is in a position to take instruction as to file an objection or not. List according.
Oblige.
So we have filed I lordship condemnation of delay 884 days. Filing the present RS.
Issue notice to steps by registered and issue notice returnable by 6 weeks. Steps by way of registered.
42.
But there is a delay of 11 days.
At the issue notice. Yeah, going. Returnable 4 weeks. 6 weeks. Same. It issue notice. So I got to 11 days. This is 61 days. Huh? This is an application under section 5 of the Limitation Act 19 for condoning the delay of 11 days. Take it or issue notice, making it returnable by 6 weeks. Petitioner, the applicant is directed to take that registered by within 3 months.
Or there is a delay of 18 days.
18 days.
Oblige.
45 is yours?
36.
Okay. And the next one, 46? 46 way. 46 is different.
46.
Notice is too good. Huh? Delay. Delay, huh? Delay of 39 days. Huh? You are not there in New India? It is filed by R. Gustami. Okay. Issue notice to it.
Limited.
Lodging I got directed to take step 2 to 4, my lord. I register as well as well, my lord. I'll do it by tomorrow.
Huh?
I'll take step by
Fail to take steps upon the respond number 1 to 4 within a period of 7 days to have both by way of remand shall then automatically vacated without any further reference. So it has been vacated. Order has been vacated.
Yes, my lord.
Upon respondent number 224.
224, my lord. My lord, in fact, my lord, they are not necessary party. This case is listed at my instance, my lord.
Okay.
My lord, they were the, my lord, main defendant, my lord, in the suit, my lord. And they were made, my lord, pro forma respondent in this instant revision application, my lord.
What is this challenging?
Challenging, my lord, order dated, my lord.
Challenging, my lord, that the tag number and pattern number was, my lord, that wrong. That after at the time of execution, that amendment petition is, my lord, filed for correction of, my lord, decree by another pattern number. That was that case. My lord.
Then that was allowed.
That was allowed.
That was allowed.
So what is wrong?
But
It
that-
can be done by as per Sushila Devi's judgment, 2003 for 2. Isn't
Okay. Yes, my lord.
it?
Maybe taken up at any.
Okay. Counsels appearing on behalf of the respondent parties agreed that the matter be taken up for final disposal on 8th of April 2024. Please take over.
In the meantime, may I take steps, my lord, or let it be.
He says not necessary.
Not necessary, my lord. They were main defendant, my lord.
Yes,
They were main defendant, my lord, and
earlier,
in this case, my lord, they were
now
made
here is proper.
pro forma
manner.
respondent.
It can be without. Of course.
Yes, what is this?
My lord, court of petitioner, my lord, kindly adjourn the case for the day.
Understood, but whose order it is? Are you seeking review against what order? Yes, why are you asking for review?
My lord, I'm not aware of the facts.
And request of the petitioner. Applicant, matter, review applicant, the matter stands adjourned to be lifted again after 2 weeks.
If I
Lordship, I appear for respondent number 3, Lordship. And respondent number 3 has expired on 19/8/2022, 2022, Lordship.
2000,
22.
Ms. Twenso, appearing on behalf of SOD, appearing on behalf of the respondent number, that the learned counsel submits that her client, that the respondent number 3 had already expired on
19/8/2022.
19/8/2022. Which, taking into account the above, matters and be listed up to 4 weeks. If the appellate, the petition be at liberty to take it.